Good morning, folks. It is January 13th. It's 9:01. This is the Colorado Oil and Gas Conservation Commission. This is day 2 of our weekly hearing. We will start with roll call.
Thank you, Mr. Chair. Commissioner Bogue. Commissioner Gonzalez.
Here.
Commissioner Hackett. Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Okay, very good. We will continue with the agenda item. This is docket number 2108-00131, a matter involving Caris Piance LLC, looking to elevate the attorneys and counsel and witnesses to the panel. Thank you for starting that work there, Hearings Manager Larson. We will give everybody a chance to zoom in, and then I'll set the stage for this morning's agenda. And Mr. Neslin, I believe you had 2 additional witnesses this morning. Do you want to name them out so that we make sure we get them to the fore?
Certainly, Commissioner. The 2 witnesses this morning will be Mr. BJ Russell and Mr. John Andrews.
Very good. We will bring them to the Zoom panel here shortly. While we're doing that, Mr. Neslin, do you have any procedural matters ahead of moving toward witness testimony for us?
Well,
I hate to ask that question, but I feel like it makes sense.
Commissioner, since you asked, Chairman Robbins, let me say yesterday, the staff suggested that Caris had acted precipitously in filing its hearing application. And several of you asked questions about why Caris didn't attempt to work through these issues with the staff through a FER or otherwise. I want to point you to the stipulated facts that the staff approved and signed, which summarized the communications between the staff and Caris preceding the filing of the application, and which I think answer the questions that were posed. Mr. Goals, do we have a slide that has the relevant paragraphs on it that we can put up?
We do, though I'm not allowed to share my screen currently.
Okay.
Why don't we-
We're remedying that. Give us 1 moment. Mr. Goals, you should be able to share your screen now.
Okay, thank you, Ms. Larson.
And I apologize. My colleague, Mr. Goals, is at one office, and I am unfortunately at home. So if we could go to paragraph 68. And these, again, are the stipulated facts that the staff approved and signed. And paragraph 68 stipulates that Caris sent a letter to Director Murphy requesting closure of the D28 and H29A inspections on April 30th. Caris copied Mr. Trujillo, Ms. Arthur, and Mr. Leonard on the letter. The letter explained why Caris believes the well sites complied with the rules cited by Mr. Trujillo. The April 30th letter is Caris's Exhibit 7. So you have that letter, and we'd urge you to review it. It's 3 pages long and details some of the concerns you heard from the Caris witnesses yesterday. Paragraph 69 stipulates that the staff did not respond to the letter. Paragraph 70 stipulates that counsel for Caris spoke with Mr. Leonard on June 23rd, and that Mr. Leonard advised Caris that if it was dissatisfied with the corrective actions in the inspection reports, then Caris should seek a hearing before the commissioners. That conversation is summarized in Caris's Exhibit 24, which is an email from me, Caris's counsel, to Mr. Leonard, and we'd ask you to review that too. I'll represent to you as an officer of the court that the email accurately summarizes my conversation with Mr. Leonard, and that Mr. Leonard did not respond to that email. Caris subsequently filed the application about a month later, on August 6th, as Mr. Leonard advised. We can also offer Holly Hill, who was involved in this process for Karis. She's the regulatory manager, and who signed and sent the April 30th letter as a rebuttal witness on this issue. We didn't list her as a witness in our case in chief because we believe that the stipulated facts resolve the issue. But if not, or if you would like to hear testimony from Ms. Hill on this subject or ask her questions, we will offer her as a rebuttal witness. Thank you.
Thank you, Mr. Neslin. Mr. Kirshner, I'm going to give you a second to respond, but before we do that, Mr. Neslin, the framing of the complaint, if I can say it that way, in the form of a declaratory judgment action, and I'm putting asterisks around that, or in the alternative of variance, was that just sort of the legal decision of looking at our rules to try to determine, okay, if we're told to come to the commission, how do we do it? I mean, I've not seen a deck action for compliance before, and maybe we've had them and I've just been dense, but can you talk to that a little bit?
Yeah, certainly. You know, again, Mr. Leonard indicated that if Karis was unhappy with the corrective actions, it should go to the commission. And so the question is how to do that. And I think your summary is fairly accurate, Chair Robbins, that we looked at the rules and we looked at the different applications that could be submitted for this purpose, understanding that we would need some form of application to get before you. This fit into the catch-all provision, we believe, for submitting an application. And we also believe that Karis is entitled to a variance. And so we combined the two.
Thank you for that. And Mr. Kirshner, will certainly like to provide you and staff with an opportunity to respond. Wasn't necessarily the procedural thing I was thinking we were going to hear about, but we're all trying to work through this. The rules of civil procedure are applied somewhat loosely, so I'm comfortable with where we are, but I would like to hear from staff.
Thank you, Chair Robbins, and I'll be brief. Council is correct. The stipulated facts, staff does agree to that timeline. I think the stipulated facts do accurately portray what happened here when you take them into account alongside the testimony that was given yesterday. As you heard yesterday, staff went out, inspected the sites, provided inspection reports with corrective actions. Karis then began doing work that applied to those corrective actions. We heard that yesterday from numerous Karis personnel. However, instead of following through with the established procedure, Karis admits and staff agrees that Karis simply wrote a letter to the director asking that those inspection reports be closed. Now, Karis did CC the reclamation team, but the reclamation team's job is not to respond to letters sent by council to the director. That's simply not something that staff does. So I think the description given by Mr. Neslin, the stipulated facts, does provide an accurate glimpse of what happened here. I'd ask that the commission consider it in light of the way Karis acted following those inspection reports and following Karis's failure to file any field inspection report resolution forms or notify staff directly that any work was being done at the site. They merely went directly to the director and asked that these inspection reports be closed. Thank you.
Great. Thank you, Mr. Kirshner. Anything from your end, Mr. Kirshner, on any procedural matters before we dive into witness testimony?
Nothing procedural today. Thank you.
Okay. Any questions from commissioners ahead of moving into the witness testimony? All right, seeing none. Mr. Neslin, please call your first witness.
Thank you, Chair Robbins. Our next witness will be Mr. BJ Russell, and my colleague, Mr. Goltz, will be presenting Mr. Russell.
Good morning, BJ. Are you there with us? You're on mute.
My apologies. How's my video or my audio?
That's good.
It's good.
All right.
Commissioners.
Good morning. Go ahead,
Karis would
Michael.
like to call Mr. Brent Russell.
Good morning, everyone. I'd like to start out by telling everyone a little bit about myself. I'm currently employed by Summit Services Group as a third-party stormwater compliance consultant for Karis Oil and Gas, as well as other companies. I've been the Western Colorado Operations Manager for almost 10 and a half years. So Summit consults on stormwater and reclamation compliance under CDPHE, Cogcc, and local government rules. Summit's stormwater and reclamation compliance consulting stretches across Colorado, Utah, and Wyoming. In addition to a number of oil and gas companies, we also assist Excel Energy, Tri-State Energy, Shaw Construction, Western Constructors, and several CDOT project contractors, as well as over 50 additional small commercial and residential developers. Summit also provides consulting to a number of local government entities with their municipal separate storm sewer systems. Along with advising clients, I also have the responsibility of training and assisting my employees to understand and interpret EPA, CDPHE, Cogcc rules and regulations, as well as industry standards such as BLM, U.S. Forest Service, CDOT, Mile High Flood District, and local counties and municipalities. Prior to Summit, I was a project superintendent, later project manager and reclamation manager for Clark & Company, Inc. I was responsible for multi-million-dollar construction projects and the reclamation division. Clark & Company reclamations projects stretched across the state in various industries such as highway projects, oil and gas, pipelines, energy and utilities, state and federal projects, as well as many commercial projects. In addition to working for Summit, I'm a small business owner. I'm proud to be the 5th generation cattle rancher and farmer in Western Colorado, where I've learned firsthand about soil health, erosion control, topsoil conservation, crop rotation, native vegetation health, livestock grazing management, noxious weed identification and abatement, as well as water conservation. I've obtained 2 majors from Colorado Mesa University, one in business management, one in business marketing, and I'm currently a certified inspector of sediment and erosion control. Having had the opportunity to work for Summit for nearly 11 years, I've conducted over 10,000 compliance inspections in the Piceance and Uinta basins for many different operators. I've visited approximately 4,000 different locations where the terrain and ecosystems are very diverse and challenging. More specific to this hearing, I inspect locations on an annual basis around the East Fork Mine Bench. I visited the D28 and the H29A most recently on November 19th of 2021. Before diving into some of the site photos of these 2 sites, I'd like to summarize 5 key observations. BMPs such as run-on ditches, grading techniques, diversion ditches, berms, culverts, sediment traps were all employed at the sites and functioning as Karis intended them to. The slopes identified by the Cogcc inspector do have established vegetation to help minimize erosion. There is a great vegetation and rock riprap in the diversion ditch and outfalls to prevent channeling and transport of sediment. I did not observe any potential for sediment-laden runoff from the locations at their outfall points. The summary of my assessment is that the stormwater control measures currently in place are adequate to minimize erosion, site degradation, and transport of sediment off-site. With that in mind, I'd like to walk through some of the site photos from the exhibits. The sediment and erosion control measures employed at these locations will be evident in these photos. I'll begin with the D28, specifically the areas of the site where the inspector found to be inadequate with stormwater management. I'm going to share my screen at this point. Can everybody see my screen?
Yes.
All right, we'll start with this photo here. This is Exhibit 13 from Caris. What we're looking at here is a run-on ditch that is fully vegetated with a fully vegetated channel. Let me get my cursor here. Right here
May-
where we're
May
talking.
I ask a quick question? Do you happen to know which page of the Caris Exhibits PDF this is?
This would be page 30 of Exhibit 13. If you can
Thank you.
see up at the top, each of these photos has the reference to the page.
Thanks, I missed that. I appreciate it.
No worries.
So for the witness, the page number is the number that's within brackets at the end at the top. Is that right?
Correct.
Okay.
So what we're looking at here is a run-on ditch that has a fully vegetated channel to minimize erosion from the concentrated flows. In this case, this run-on ditch was constructed to intercept stormwater from the areas above the location, which would be natural runoff. And the area in question here is right here. This is the cut slope that we've been talking about. This is downgrade. The runoff ditch is here. We've got another diversion ditch at the toe of this cut slope. This is what we would call one of our outfall locations. And we've got this photo here to show that the diversion ditches and channels are free of any sediment deposits, and the vegetation is thriving and looking well. Moving on here, this is back over to the west side of the location. You can see a diversion ditch constructed right here. This is below the cut slope in question right here. And kind of, it's gonna tail around and come down to the location down here. The reason we've got this photo shown is just to show that we've got no signs of sediment deposition in these flow lines here. And this is moving down with another angle at this. This is a rock riprap channel we put in place to prevent erosion. And you can see there's no signs of sediment deposition there. Zoomed out photo, again, our cut slope in question is kind of up here to the right. And finally, this diversion ditch comes down to the pad surface here, where it becomes intentionally flatter. And the reason for this is to allow any potential sediment to settle out, and also promote any runoff to kind of infiltrate the ground and not discharge off-site. Another photo of our diversion ditch here and the cut slope in question above. If there was evidence of erosion, significant erosion on these sites, we would see it here at the toe of these slopes and in these channels and diversion ditches. So the next BMP employed at this location is vegetation itself. What we see here is photos that were taken in July when vegetation is in its growing season. And we use this vegetation as one of our primary defenses against erosion. There are small areas here on the cut slope that have less revegetation density than maybe the ones down below. But it is similar to reference areas throughout the area in the East Fork area. Finally, in 2021, these slopes were hydroseeded and hydromulched to promote further vegetation establishment. And this is yet another BMP designed to mitigate erosion. And you can see the green hydroseed hydromulch here on these slopes here, as well as here. So now I'd like to take a look at the inspector's photos. Overall, I disagree with his assessment that Caris's BMPs are insufficient, mainly because I didn't observe any signs of significant erosion and ultimately sediment deposits. It's important to note that the BMPs I just discussed, which are right here, the upper run-on ditch, the lower diversion ditch, and vegetation are all working together on this site to protect the cut slope and treat stormwater runoff, as well as prevent soil loss. Our first photo here is Exhibit F. I think it's pages 47 in the exhibits. This shows a reclaimed slope with a young population in early spring that has not yet seen its potential due to the fact that it's not in the growing season yet. So the photos I just showed here and here are the full potential of this slope when vegetation is in its growing season. This photo also shows other BMPs that are employed at this site. Right here, the run-on diversion ditch, and down here, the lower toe diversion ditch with no signs of sedimentation. Moving on here, the run-on ditch at the top of this slope is also shown in this picture here. And this will help manage stormwater and protect this cut slope while the revegetation continues to progress. Most importantly, there was no sediment accumulation in these ditches or damage to the vegetation from sediment and erosion. That this would be evident if there was slope erosion or soil loss. Next, we'll move on to staff's Exhibit F. I think it's photo 3 right here. This, according to the inspector, this shows destabilizations and that BMPs are not adequate. Well, I disagree. I see no substantial slope instability or erosion here, such as water cutting or channeling the soil. And again, there are no significant sediment deposits in the downgrade BMPs or outfall points. There appears to be some evidence of minor instability, but this is to be expected in these extremely steep slopes with these soil types. Photos 5 and 6 here actually show the effective run-on ditch. These channels are vegetated and are protecting the cut slope below. There might be some signs of minor instability, but nothing that means this ditch is inadequate for this location. Staff's Exhibit I in photo 1. Again, there may be some instability, but this ditch is actually protecting the cut slope much more than it harms it. These soils are naturally unstable and challenging to revegetate, but this ditch is protecting the cut slope from much more significant erosion. Photo 2 here shows that there's no signs of erosion below this ditch. Here's the cut slope run-on ditch, and this is the cut slope in question here. Additionally, here on photo 3 of Exhibit I, shows that vegetation will continue to progress to protect the slope. These photos don't show that BMPs are inadequate. It shows a young vegetation continuing to progress into mature populations. Staff's Exhibit G, page 85 in the exhibits, photo 7. This describes in this photo here a 2-foot elevation change due to soil loss between the arrows right here. I don't believe that there was any soil loss. There's no evidence of that downgrade. This particular ledge likely settled in and balanced out just above the run-on ditch. This is what happens in these scree slopes in the Piceance lower valleys. Finally, I'd like to note that going back in to recontour this ditch and this cut slope would actually destroy its effectiveness by disrupting the healthy, mature vegetation already existing in these areas. And it would cause more severe impacts than what's shown in these photos. So overall, I do not agree with the decision made by the inspector that Caris does not have adequate BMPs to address these site conditions. I see no substantial erosion, degradation, or signs of soil loss that would be evident in the BMPs if this was the case. Next, I'd like to move on to the H29A. And more specifically, the issues identified by the inspector. But first, I'd like to explain the sediment and erosion controls employed at this location. The first is, again, a diversion ditch. You can see the diversion ditch here running along the toe of the cut slope. The vegetation in this ditch slows the water in the ditch and protects it from erosion, and also helps sediment settle out. We see the diversion ditch again here, fully vegetated. This is an adequate BMP employed as a part of an interim sediment treatment train employed at this location. But more importantly, there's no signs of sedimentation in this ditch or damage to the vegetation that suggests the slope above is unstable, eroding, or experiencing soil loss. This cut slope in question is right here. Next, we'll move on downgrade where that diversion ditch leads to. What we're looking at here is a sediment basin, a culvert, and eventually where the culvert outlets to a rock riprap apron. This sediment trap here helps settle out any potential sediments that could be accumulated in the runoff from the location. Here's another view of that sediment basin right here. This is a culvert inlet. This culvert is a BMP utilized to properly convey stormwater through the location without erosion. This culvert outfalls into a large riprap area with no signs of sedimentation or erosion, as shown in the following photos. These photos show the final outfall of this location of stormwater runoff from the H29A, including the cut slope criticized by the inspector. The BMPs I just described all work together to manage stormwater, minimize erosion, and minimize the potential for sediment-laden runoff from leaving the site. If there was evidence of soil loss, it would be in these photos. And as you can see, we don't see any signs of sedimentation or sediment discharge. Finally, the cut slope at the H29A has established vegetation to help stabilize the soil, as shown in this photo here. As we explained earlier today, Caris's cut slopes actually have more vegetation than some reference areas. Now I'd like to take a look at some of the, oh, here's another photo of a reference area. My apologies. We're looking at the cut slope in question here with reference areas in the background. Now I'd like to take a look at the inspector's photos, starting with staff's Exhibit D, photo 7. So this photo actually shows vegetation as a BMP with no signs of noticeable erosion, cutting, reeling, anything of that nature from runoff. As you can see in the cut slope toe diversion ditch, we have mature vegetation in the flow lines and no signs of soil loss from the cut slope or in the diversion ditch. Second, going back to Exhibit D here, I don't see any signs of significant erosion here, even in March after the snow melt when vegetation is not yet in its full growing season. If there was an issue, I would expect to see erosion channels formed from water cutting the cut slope and moving the soil. There does appear to be minimal example of this in this photo here, photo 8. We're looking at this minor reel right here, but we're looking at a reel that is maybe 1 to 2 inches deep at the most and doesn't even reach the toe of the slope. It's also it's not uncharacteristic to see this in these areas. The native slopes around show this naturally. We have one right here. For example, in this photo here, this slope shows established vegetation and no signs of significant erosion. So let's compare this photo to this photo. There are slopes outside the limits of construction that look similar to our cut slope. Here, over here, and more importantly, a zoomed up photo of bare areas on a non-disturbed slope. Again, another example of slopes that are outside of our construction boundary that look similar to our cut slope. Finally, I'd just like to point out again that the inspector's photos just do not show justice to the vegetative success on these cut slope. He's zoomed into bare areas. But if we take a step back, as in this photo, there's a lot of mature vegetation here. And it is stabilizing the soil. Finally, on this last photo here, our cut slope in question is right here with a reference area off in the distance. And you can see that our cut slope is similar to the surrounding areas and the reference areas. So in summary, I believe Caris's stormwater management team uses common sense and good engineering practices approaches to stormwater management and reclamation. These individuals are the best in the industry. The focus of the Cogc stormwater rule is to control stormwater runoff in a manner that minimizes erosion, transport of sediment offsite, and site degradation. Caris's sites have BMPs that are adequate and designed to do just that. I believe the inspector did not take the entire plan that we have into consideration. As described in my testimony, there's a number of BMPs working together to ensure these locations protect the environment, starting with the surface areas itself and ending with water quality. I would also like to point out that completing additional work to address the inspector's criticisms would actually be very harmful. Additional action would destroy years of revegetation progress on these slopes and cause a greater potential for erosion of the slopes and ditches in question. Finally, this work would add additional environmental impacts such as air quality from dust, equipment, and trucking. In my opinion, these sites already have appropriate BMPs designed to minimize erosion and sediment transport. I make that assessment confidently since there are no signs of slope reeling or sediment deposits in the BMPs or outfalls downgrade of the areas identified by the inspector. Thank you.
Thank you, Mr. Russell, for the testimony and the evidence. At this time, I believe Mr. Kirshner will have an opportunity for any cross-examination.
Thank you, Chair Robbins. Thank you for your testimony, Mr. Russell. I'm going to try to share my screen. Once again, please let me know if this happens to go sideways. Mr. Russell, can you see the photo I'm showing here?
I can.
And this is one of the photos you showed earlier to describe the stormwater BMPs, the D28. Is that correct?
Yes,
Okay. Just real simply, do you know whether this is one of the areas that the inspector identified as an area of concern?
not that specific area. It's above it.
Okay. And how about this one? Do you know whether this is an area that the inspector identified as an area of concern?
Again, that specific area, no, but it's the area's upgrade that would be able to drain to that area.
Okay. And then one more photo from this set. Okay. I'm going to try to zoom in here because you showed this as an example that the BMPs are working as described. That might be a little bit too tight. Just 1 second. Okay. You showed this photo, and once again, where my pointer is here, this shows the diversion ditch. Is that correct?
That's correct.
Okay. And above this, how would you characterize this cut above the diversion ditch?
I'm not sure I follow your question.
That's okay. We can get into that with Mr. Trujillo when we talk to him. I'd like to move on to Caris's Exhibits Volume 2. Just share my screen real quick. Can you see this photo?
I can?
And this is one of the photos you showed during your presentation, isn't that correct?
Correct.
You showed us this image to describe how vegetation is being used as a stabilization measure.
Mhm.
Now, you told the commission that in 2021, these slopes were seeded and they were hydro-mulched to mitigate erosion as part of a stabilization measure for stormwater BMPs. Is that correct?
That's correct.
Okay. Once again, this photo was taken on July 29th. Isn't that correct?
That's correct.
When was this work done, the hydro-mulching?
I'm not sure. I was not a part of that. I didn't prescribe that work or suggest that work, so I'm really not sure on that.
That's okay. We heard testimony yesterday that that work was done on July 27th. Now, that was after the inspector's visit. So this photo here, this doesn't portray the conditions at the location at the time of the inspector's inspections, does it?
No.
Thank you. I'm going to show you another excerpt from staff's exhibits. One moment. Okay. You showed this photo here during your presentation, is that correct?
I did?
I'm sorry, that's not the right photo. Just one moment. Okay. So this is one of the photos you showed during your presentation, and you noted correctly that this photo was taken during the March inspection. You said that the vegetation was incomplete. Is that correct?
No, I did not say that. I said it was a young vegetation, not yet in its growing season for the year.
Thank you. And I didn't intend to mischaracterize your testimony. I just used the wrong word. So that was my mistake. So if the vegetation is in its younger status, it's not in the growing season yet. Karis is saying that this vegetation as part of the BMPs constitutes adequate stormwater controls around the location. But if this vegetation hasn't come in yet, if it's not fully stabilized yet, how can staff make an assessment that these BMPs are adequate when this vegetation functionally doesn't exist yet?
I wouldn't say that the vegetation doesn't functionally exist. There is root structure. It's just not in its growing season yet. That is typical of a ecosystem in this area.
I don't disagree. I'm really saying that in its state, in this photo, as observed in March during the inspector's inspection, would you expect this BMP to function at its utmost to control stormwater?
Yes, because that's the way the natural ecosystem works as well.
Okay, thank you. One more photo from staff's exhibits here. This is the D28, and I'm going to try to zoom in.
Let me just add to that too. We also have additional BMPs employed, as in my testimony I described, that are there to assist with that cut slope as well.
Thank you. So you flagged this photo during your testimony. You said that, I don't want to mischaracterize. Can you describe what you said about this cut?
So basically in my testimony, what I said is that, okay, so let's step back here. The inspector says that there is evidence of soil loss. And I basically had this picture in my testimony to show that I don't believe there was soil loss. I believe there was a minimal soil movement in this area, but not soil loss. And the soil that did move did not even impact our BMPs that were in place.
Okay, so you would characterize it as a soil movement and not a soil loss.
Correct.
Okay. To your knowledge, did this head cut exist prior to the oil and gas disturbance?
I have no idea.
Okay, thank you. Let's move briefly to the H29. I'm going to pull up another one of Karis's exhibits. If you'll give me just a second, let me make sure that I don't leave this one anymore. The computer doesn't like opening multiple PDFs at once, so please forgive me. I have to open and close several things. Okay, thank you. This one. Mr. Russell, can you see this photo?
I can.
Is this one of the photos that you showed during your presentation?
It is.
Okay, thank you. Once again, I'm going to refer to the date stamp here. This image was taken on July 29th, isn't that correct?
It is.
Can you tell us kind of this little darker section? Can you tell us what's going on here?
That is obviously hydroseed, hydromulch.
Okay. And once again, you know, Karis testified yesterday that this hydroseeding mulching operation, this took place on July 27th. So that was after the inspector's visit to the H29A, isn't that correct?
That would be correct.
Okay.
I think my intention of this photo, though, was to show how the current vegetation, not including the hydroseed, hydromulch, resembles reference areas.
I appreciate that. If we're using a picture from July 29th, what can this picture tell us about the state of compliance when the inspector was on site on March 9th observing this?
Again, you know, on March 9th, the vegetation was not in its growing season.
Okay. The inspector visited the site again on July 22nd. That was a week before this. And all of this work, this was done after. That's correct.
The vegetation would have looked the same during the inspector's visit as it would in this photo right here.
But the slope wouldn't have looked the same, would it?
Well, obviously there wouldn't be hydromulch on it.
Thank you. Just a couple brief additional questions. You said earlier that the inspector's photos, quote unquote, zoomed into bare areas. Wouldn't you want the inspector to show with specificity the areas with which they're concerned?
I could see him needing to zoom in to show his concerns. I guess where I was going with that was that to get an accurate analysis of that slope in the vegetation, you need to step back and look at a reference area and the surrounding areas of the native vegetation.
Thank you. You also referred to vegetation in the diversion ditches during your testimony. Did the inspector specify any corrective actions related to vegetation in the diversion ditches?
No, sir.
Okay. And finally, you told us that Karis should not be required to comply with Rule 1002F because of the impacts related to stormwater work or the impacts of moving soil around, et cetera. And I don't want to mischaracterize your words, so I'll just say that you were concerned about the impacts of doing further work here.
So I definitely didn't say that they don't want to comply with the rule. I feel that they've already complied with the rule.
Thank you. I think I'm more concerned with your statement that doing further work would require impacts. Is it your testimony that because this work would require impacts, that oil and gas operators shouldn't be required to do any further work if concern is identified?
That's not my intent at all.
Okay. Thank you. I have nothing further, Chair Robbins.
Thank you. Mr. Neslin, any redirect?
Yeah, I'll do a little redirect. Thank you, Chair Robbins. Mr. Russell, Mr. Kirschner asked you some questions comparing the conditions between the March 9th, 2021 inspections and the photos depicted in July, and explained that, or asked you whether you believe the conditions in July would have reflected the conditions in March. And sorry if I don't mean to mischaracterize Mr. Kirschner's question either. Do you have any concerns about the inspector evaluating cut slopes in this terrain in March?
I don't have any concerns because I know that, they've got to go out and do what they need to do. It's just, it's difficult to get a good picture in this area of what vegetation is actually going to be like during the growing season, which is a majority of the year. But not only, on locations, native vegetation in the surrounding areas that has never been disturbed looks similar. We've got livestock and wildlife that graze the grasses down to nothing in some areas. So you can't make a full assessment on what revegetation needs to happen in March.
Thank you. And Mr. Kirschner asked you whether some of the photos you displayed of the diversion ditch at the toe of the slope or the rock riprap armoring at the toe of the slope were areas identified by the inspector as problematic. Do you believe that those elements of the sites are relevant to the inspector's evaluation of the success of BMPs?
They are, for a number of reasons. The most important reason being that if there was any erosion or sediment movement through the site, you would find it in these drainage channels. You would see evidence of something negative impacts that are occurring on the site. And that's where we look as a stormwater inspector. You look in the channels, the stormwater flow lines per se.
Thank you, Mr. Russell. I have nothing further.
Okay, thank you for the testimony. I now will look to my fellow commissioners if anyone has any questions of this witness. Commissioner McGowan.
Thank you, Mr. Chair. And thank you for your testimony today, Mr. Russell. It's helpful to have your perspective. I have a couple of questions that might seem ignorant, so if you could bear with me, I'd appreciate it. As you're implementing best management practices for stormwater, are the best management practices aimed towards I'm trying to figure out how to word this. Do you build them to anticipate like some sort of significant event? Like you have to have them so that it controls erosion if it were to rain for 15 days. Could you explain to me a little bit like how much you had to anticipate or how rigorous the BMPs have to be to anticipate some sort of rain or erosion event? I don't know how to explain myself. I hope I'm being clear about what I'm trying to get at.
No, you're perfectly clear. So to start out, the industry and most rules and regulations use a phrase called good engineering practices. And that's kind of how permits and rules and regulations follow. CARES has a stormwater BMP manual, and it's been designed for this area. It's used multiple different engineers to come up with these designs and specifications to give us a guideline on how to build these things and how big they need to be. So they have a book that has every type of different BMP in it that you could use, and you follow that when implementing these.
Okay, so I assume the book or the manual is aimed at meeting CDPHE's requirements for stormwater best management practices. And I'm trying to figure out, and maybe our COGCC folks can help me figure out what you're building to. I get that you have a manual, it has best management practices is. I'm trying to figure out what the best management practices are based on. So I'm going to stop there because maybe you don't know the answer. Maybe someone else does. And so,
I'm sorry.
go ahead.
They're generally based on that good engineering practice. There's a number of different manuals out there. One of them is the Urban Drainage Authority. CDOT has their own set of standards that they've designed to meet, basically Colorado's rain events. A lot of them use a 25-year storm. Some of them are not from this state that you can find specifications on. So they'll use a different number. But basically, it's if you can meet good engineering practices in these BMPs, that's what's expected of us.
So if there were a 25-year storm, the best management practices would prevent erosion or vegetation from sliding down or sedimentation getting into creeks or rivers downstream, et cetera.
Correct. They are designed and implemented to meet that storm.
And do you think the Western Slope has had typical rain or storm weather events in the past 5 years?
We've had some pretty significant 12-hour events over here this last fall.
I'm just trying to figure out like if there's actually been any sort of precipitation, because I know y'all are we're in a drought. So it's unclear to me like how much we can gauge whether it's working or not if there's been precipitation. So I was just curious.
Yeah, I mean, there's no doubt that we've been in a drought for a couple of years, but we have had some significant rain events just out of the blue that have impacted these areas, and these areas in general get these big heavy rain cloud bursts on a regular basis.
Thank you. And then so I'm rereading our rule, which is for interim reclamation, that uniform vegetative cover has been established that reflects pre-disturbance or reference area for shrubs or grasses with percent plant cover of at least 80% of pre-disturbance levels. And in some of those pictures, it doesn't look to me like it's 80%. It looks like there's fewer plants. And I'm wondering if you're saying that's because those plants haven't grown yet, so you can't see the 80%, but it is 80%. I'm wondering how you see that rule is being met.
So what I was showing in those photos was that outside of the construction boundary, there are also native bare areas that don't show vegetation. So when you step back and look at the site as a whole, you're going to have patches that don't grow in completely. Basically, when we look at it at ocular assessment of this, a visual assessment of this, you want it to overall match what's existing.
So sorry. In the places where revegetation has been started, has it been started in those areas because construction has disturbed those areas? I mean, you wouldn't be revegetating an area that you hadn't touched, that wasn't affected by the oil and gas footprint, correct? You wouldn't just go out and start revegetating?
No, not at all.
Okay. Thank you.
Yep. Thank you.
Other commissioners with questions? Commissioner Messner.
Thank you, Mr. Chair. And thank you, Mr. Russell, for sharing your experience with us. I have a couple of questions just to understand your interpretation of the rules and just generally the site itself. You may or may not know this, but I'm trying to understand just general timelines, how old these cut slopes are, how old these diversion ditches are, how old this vegetation is, how established it is over what amount of time.
So I think we'd have to refer back to that timeline that Lindsay shared. I, off the top of my head, cannot come up with those dates. I'm gonna say it was reclaimed, I think they said in 2012, maybe. But
Yeah, and I'm
not
talking
sure.
about these specific areas too. And so you may not know that. I mean, I know that there's like holistic timelines, but I'm also looking at like this particular cut slope that's of concern, or this particular slope above the diversion ditch that perhaps is concern, or these specific things, whether it all happened at once or whether there was different work at different times. And so I can
Yeah.
review that or ask someone else if that's not in your knowledge area.
Yeah, I apologize. I don't know the dates on that.
That's okay. So a couple questions as far as your interpretation of the rules. I mean, the rule does indicate a couple of different thoughts on kind of adequacy of revegetation, and one of them is reference areas, and one of them is adjacent areas or pre-disturbed area. When you're looking at instituting best management practices, are you looking at like the best management practice being 80% of the adjacent area or the undisturbed area, or are you looking for a reference area that is as disturbed in determining what the best management practice is for revegetation?
Can you explain what you mean by the best management practice for revegetation?
Sure. I mean, you're indicating in some of your testimony, or you're showing a reference area that is a pretty disturbed reference area, right? And I appreciate that it may be a natural area, but it's pretty disturbed and there's some significant erosion occurring in those areas. Whereas my question is that there's pretty good vegetation on the adjacent area, which is like a good reference area for determining what the adequacy of vegetation should be in this particular disturbed areas. And so I guess my question is your goal to make it look like a disturbed area, reference area, or to be 80% of the adequacy of the existing vegetation adjacent to the particular cuts that you're trying to address as a best management practice?
Right, yeah, so I understand where you're coming from now. So basically, when we look at these sites, you know, we want a uniform coverage. But we also know that there are going to be some bare spots. And those bare spots over time, we're still in interim phase of this site. It's still producing. It's not final reclaim. What we're looking at is to minimize erosion and try to, you know, keep that vegetation progressing towards, you know, a better, you know, density. But, you know, right now, when you look at these cut slopes, to go in and destroy what vegetation is that's there, to me, would be more damaging than just to let it keep progressing. Now, if we saw significant erosion on these slopes, then yeah, some kind of action is probably warranted to mitigate that. But, you know, you're not seeing any of that cutting on these slopes. And to allow that vegetation to just naturally keep progressing, in my mind, is the best management practice. Knowing that we've got also other BMPs in place in case something happens. And if something does happen, Karis is good about going back in and fixing this stuff.
I appreciate that. I mean, I was really just trying to understand like what your goal is, right? And so whether your goal is to have this reference area as your goal, or whether it's the adjacent vegetation. So I understand your interpretation of the rules. So I appreciate that answer. And you did indicate, you know, there's some instability that you feel is kind of palatable. And then I think you just indicated that there's some other instability that may be problematic. And what's in, like, as you're looking at best management practices or how you interpret the rules, what's an appropriate amount of instability? Because there is some sloughing, some instability that you've indicated in some of the photos that you showed. like, what's that threshold as far as determining what's adequate or what's palatable instability versus what type of instability would require additional action?
I think in this case, if you're losing soil from your slopes and it's migrating past, into control measures below, that's a sign that we need to, address this. And size too. These slopes, the areas that you can see that were in green that we hydroseeded, you're talking a couple thousand square feet. If we had a cut slope that was a half an acre and it was bare, you're looking at a lot more water head and a lot more potential for erosion on a bigger slope. These slopes that are in question here are small areas in the big picture that are showing some vegetation progression through every year that we go through a growing season.
And let me just ask one more question about that too, because that was another question I had as far as like your interpretation of best management practices. Understanding that there has been some conflicting testimony around kind of growing season versus dormant time as far as vegetation goes. And I imagine we all know that runoff occurs in dormant times as well as in growing season. And so is there different expectations for vegetation in the dormant season, or how does vegetation in the dormant season still address erosion control versus in the non-growing season, I guess? Because it seems like there's a big discussion about this, but it seems like there's always going to be a dormant season. There's always going to be a growing season. There still has to be some sort of erosion control. So how does that all occur?
So root structure plays a big factor in that during the dormant season. So in this case, if we were to assess, if I was to assess this site and determine that action is needed, if we were out there in March and saw significant erosion, coming down these slopes, obviously that root structure is not doing its job. So, something more needs to be applied to this. But, in these cases, we just don't see any type of cutting, any water impacts on these small areas. So, I guess to answer your question, in the dormant season, root structure is the number one combating factor in erosion.
Okay. I think that's it. Thank you very much.
Thank you.
Thank you, Commissioner Messner. Further questions from commissioners? All right, seeing none, thank you, Mr. Russell, for participating with us and for the evidence and testimony this morning. Would look to Karis's counsel for their next witness.
Thank you, Chair Robbins. Karis would like to call John Andrews as our next witness.
Very good. I see Mr. Andrews is with us. Good morning. You have previously sworn to tell the truth. We look forward to hearing from you.
Yes. Good morning, commissioners. So my name is John Andrews. I work for Karis Piance. I'm the ranch manager here, and I've been employed here since 2018. I've worked on the Rome Plateau since 2003. So I have 19 years of experience in the Rome Plateau, implementing, developing and managing wildlife programs, livestock programs, rangeland improvements and maintenance, and fisheries improvements and maintenance. I've worked with many large ranches in the Rome Plateau, the High Lonesome Ranch, Branded Rock Canyon, the LK Ranch, and many other smaller ranches. I've also consulted for Hall and Hall and Hayden Outdoors, which are ranch real estate brokerage companies for building wildlife and agricultural programs for large ranch buyers. And then I've completed some certification and education courses through institutes like King Ranch Institute, Organizations Society for Range Management, NRCS, I've worked in coordinated study efforts with the Colorado Parks and Wildlife on large scale forage manipulations using high rotation grazing. And we did a coordinated effort with the National Fish and Wildlife Service to revegetate key mule deer wintering grounds after the Pine Gulch fire. Since employed from Caris, I've been present in the East Fork Valley roughly 150 times. My responsibilities at Caris are to oversee our deeded surface. I act as a landowner representative, and I oversee and manage our wildlife mitigation plan. There's among other responsibilities. The mine bench locations that are subject to this hearing is a favorite hangout for wildlife and for livestock. There's some flat spots and a bunch of south-facing slopes. And as the landowner representative, I have evaluated these interim reclamations, and I'm satisfied with the success of the current interim reclamation. I believe further disturbance with a new reclaim would cause more harm than it would do good. The current reclaim is in line with our wildlife mitigation plan and our range management practices. The current site does not present a threat to the environment or public health, safety, and well-being. I'd like to kind of discuss the ranch and our range management practices. As you guys have heard, the North Parachute Ranch, as we refer to it, it's 62,000 contiguous acres in the Rome Plateau. The elevation ranges from 5,000 to 9,000 foot of elevation. Roughly a fifth of the land are in these low elevation canyon shrublands. The remaining lands are all comprised of sagebrush steeps, mixed mountain shrublands, aspen woodlands. Water's very limited in this terrain. It's mostly spring fed, and there's a handful of small creeks. And with that, Commissioner Messner, you asked a question yesterday I'd like to address. You asked how close the water was to the sites in question. The nearest perennial water in East Fork Creek is about a mile downstream. There is a dry creek bed, what we would call East Fork, 500 feet directly below. But since I've worked at Caris, I have not seen water flowing at that point. It's more seasonal. The East Fork Valley is a favorite seasonal location, spring and fall and winter for the resident elk and mule deer. The south-facing slopes burn off the snow faster than surrounding areas, which gives them availability to forage and graze, sooner or earlier in the year. And they also use those south-facing slopes to kind of sunbathe and warm themselves. Caris, we've put a great amount of time and resources and focus in implementing range management practices. We use a holistic mindset and holistic practices, and we really strive to achieve the proper carrying capacity of our wildlife, meaning the right population for the landscape. We focus on a healthy regenerative ecology, and we really understand that there's multiple uses of this land. With our agricultural operations and our cattle grazing, we use those as a tool to benefit the wildlife. By a high rotational grazing program with limited stocking, we promote the feed for the wildlife, the quality of the feed for the wildlife. We've implemented grazing plans that the goal is to manipulate the forage in the same manner that past ungulates, such as bison and wild sheep and elk and deer, would have affected the ecology. We've agreed with our wildlife mitigation plan to stock the range at 20 acres per animal unit month. What that means is about 100 acres per cow-calf pair during our summer grazing season. This is about 50% of our industry standard. We have adopted a leave half, take half of the forage objective. The tools we can use to help accomplish this are high rotations of the cattle, distribution of salt, and hauled water at timing of the year that will disperse the cattle amongst the range. Our goal is to manipulate this forage to keep it green and growing, meaning that it's healthy, it's growing, it's green, it doesn't turn dry and dead and dormant. I think the holistic practices, they really increase the quality of the forage within the landscape, but there's many cases where they increase the quantity at the same time. Our agricultural fields within the North Parachute Ranch, we've agreed with our wildlife mitigation plan to limit we save a full crop, or we stockpile the forage for the winter time, meaning that we leave a hay crop, or we may not even cut the hay at all, to allow for that forage to be stockpiled through the winter time for the wildlife when they come down to utilize. It's something that's been very important to Colorado Parks and Wildlife, that those landscapes, those elk and deer have that forage when they come down. I think there's two other wildlife mitigation programs that are good to note. One of them is our off right-of-way weed spraying. We have an additional extensive weed management plan that we do to inspect and treat noxious weed infestations outside of our operations areas. So we have our operations weed spraying program, and then we have our off right-of-way. And it's a very extensive program to help control noxious weeds. We also have a grazing monitoring program that we use to monitor the grazing that we allow on the ranch. We get a score essentially at the end of the year, and we use this as a tool when we meet with Colorado Parks and Wildlife to kind of judge how well we're doing. We use this tool to make adjustments and for the next year's growing, and also kind of hold us accountable to Colorado Parks and Wildlife that we're doing what we say we would do. We have quite a few additional holistic practices on the ranch that I think I'm pretty proud of, that I think shows the holistic desires of Caris. These aren't required. These are things that we've done that we think are just good practices as landowners. We've implemented multiple honeybee colonies to help with pollination. We practice no-till seeding or no-till agricultural practices to try to promote soil health. That it helps to every time you till the soil, you're hurting the soil. So we've implemented agricultural practices at no-till. We've upgraded a majority of our irrigation systems to be the most efficient. This helps us to be good stewards of our water resources. We've installed beaver dam analogs, what we call BDAs, and these are man-made beaver dams. We put these to improve riparian health with the intent to transplant beavers into these areas through CPW in the future. We've also worked with CPW on restocking the East Fork with Colorado native cutthroat. I think all these practices kind of really show that Caris has a desire to help improve the habitat for all wildlife through this. We have a holistic management, and anybody that would have the ability to, take a truck tour with me as you would drive through, I think you would see really fast how much these wildlife benefit from these practices. So the East Fork Valley, as you know, contains historical oil shale exploration and a mine bench. The valley is mostly canyonlands with intermittent creeks running through the bottom. The native vegetation is shrublands, mostly sagebrush, rabbit brush, and saltbrush. There's a small, sparse amount of bunch grasses and forbs that grow along the scree slopes. And the valley floor is very prone to rank, overgrown, woody shrubs. So when we developed the plan to graze this valley, the focus was really to regenerate the forage, to lessen the woody shrub encroachment, and to increase the forage quality for the wildlife. So we stocked it with 40 head of cattle for a short grazing period, usually 2 weeks in the spring or the fall. We regularly rotate these grazing seasons, meaning 1 year we graze the spring and the next year we graze the fall. And what this does is allows specific species plants to rest or reproduce, and it promotes biodiversity within your forage. These short grazing periods are really important to allow for ample rest of the plants, and this allows them to spread, reproduce, and it also keeps them in a palatable stage. In rangeland landscapes, the presence of ruminants are important. The native perennial forbs and grasses rely on the bacteria that gets distributed in the feces of ruminants. It allows them to utilize the nitrogen and the minerals in the soil. We also we use livestock as a tool to reduce the invasive annual grasses within the East Fork, mostly cheatgrass. We target grazing them during an early growing stage, which is earlier than the native perennials. And then in the fall, when they're in there, they help take the seed heads and beat back the competition of these invasive winter annual grasses. The cattle also help by trampling and breaking down the overgrown woody shrubs in the bottoms and the extra areas as they move and graze. This allows sunlight and other resources to reach the native forage. And then kind of a unique thing that I've witnessed in the valley, I think is cool to point out, is these cattle will graze the seed heads off of like thistle and noxious weeds at certain times of the year, which is the most effective way to keep those noxious weeds from spreading. They target it when they're flowering. They'll go through and they'll bite the tops off and move on. It's a really effective tool at reducing the spread of specific noxious weeds. An additional benefit, and I think a very important benefit, is wildlife avoidance and suppression within the East Fork Valley. By grazing off the old dead growth, we regenerate these landscapes. We keep the forage in a green and growing state. And that dramatically reduces the fine fuels that are within the valley. That those fine fuels are the most susceptible to fire. And without manipulation of these forages, the entire valley would risk a wildfire. And being it's a box canyon, there's only one way in, one way out. Firefighting efforts are very difficult, if not impossible. So as a landowner representative, it's really important to prevent these potentials for wildfires. The D28 and the H29, they're located up against a rocky scree hillside, as you guys seen in the photos. There's very little moisture, and it's extremely difficult to have successful growth in the landscape. Further revegetation is not necessary to protect the environment, as the current vegetation is already successful, and as you've seen, it mirrors the ecology of the overall native landscape. One important thing to note is soil is different than dirt. Soil contains microbes, bacteria, fungus, and organic matter. And when you disturb the soil, even with proper stockpiling efforts, the soil, it can essentially die. It hurts it, and it takes years for that soil to rebuild. The current reclaim has been healing for years, and to create any further disturbance would be resetting that healing process. And that further disturbance would then take time to heal, rebuild. Those plants would have to try to regrow. And I think it would leave this site in kind of a constant state of degradation. By removing the current vegetation that is there and trying to import more topsoil, recontouring the mine bench, we're setting back the native plant life and how it's trying to grow now. When you set back that native plant life, you're opening up a lot of risks. You're opening up to risk to rock slides, to erosion, the potential for introduction of noxious weeds, and a risk of harm to wildlife by having to fence off that area. There'll be a large amount of construction equipment, a massive amount of human presence, vehicle traffic, and additional fencing. And all this has a negative impact on the wildlife that lives within that valley. And any benefits of a further disturbance, in my opinion, would outweigh the negatives to that wildlife. The current operations and conditions already protect our wildlife resources. Are in line with our WMP and our range management practices. So to summarize, I don't think there's anybody that cares deeper for the health of this landscape or the wildlife on North Parachute Ranch than I do. With that in mind, any additional disturbance to reclaim these sites are unnecessary to protect the landscape or the wildlife. Caris's holistic range management practices successfully promote wildlife resources, local ecology, and mitigate the fire risks. And there are no risks to public health, safety, or welfare. And the current reclaims already prevent environmental impacts. For this reason, as the landowner representative, I choose to waive any additional reclaim efforts. Thank you.
Thank you, Mr. Andrews. At this time, you are available for cross-examination by Mr. Kirschner.
Thank you, Chair Robbins. Thank you, Mr. Andrews. I don't have any questions for this witness.
Supposing we don't need redirect then, is that right, Mr. Galtz?
That's correct, Chair.
Questions from commissioners? Commissioner Messner.
Thank you, Mr. Chair. I just have a couple questions. So help me understand from a wildlife perspective. I mean, one of the goals of interim reclamation is to minimize the footprint or the surface impact of an oil and gas location. What's your opinion as far as the impact to wildlife of a larger footprint versus a smaller footprint, and particularly in this area where they perhaps are accessing that riparian corridor that's 500 feet away?
So for us as landowners and wildlife managers, the impacts to wildlife for these deals has a lot more to do with the human impact that it brings. You know, if we were to recontour the whole mine bench, we were essentially putting it back to the way Unocal left it, which was a man-made way. And so to me, the impacts of redoing it are more the human impacts. The wildlife, it's a large valley that they're comfortable with, and the more people drive up there, the more vehicles that are going through, that's the impact to the animals. The few acres of disturbance that will be difficult to revegetate doesn't affect them near as much as the people element, the traffic, the dust, the fencing that we would have to do. We use wildlife friendly fencing, but there's always a risk for animals to be entrapped into fences. So all those impacts to try to fix a few acres of revegetation, I think far outweigh the benefits of a few more acres of vegetation.
Okay, thanks for that. And I mean, and I'm trying to balance this to, and I do appreciate the impacts of humans on these particular wildlife situations, but I think one of the reasons that at least I'm hearing for having a larger pad is for the ability for equipment to get in there for recompletions and workovers and things like that. What's the balance between the impact of minimizing the footprint in this particular area and the impact of these different operations that could be occurring on the site?
As far as the size of a pad, we live in a very large landscape. These animals move 5-10 miles to migrate. They move 1 or 2 miles a day. So an extra acre of compacted gravel area does not impact these animals' movements, does not impact their well-being. But additional traffic, additional disturbances could, additional introduction of noxious weeds through construction or something of that effect could have a much farther impact than whether, a pad is 6 acres versus 5 acres.
Thank you for that.
Further questions from commissioners? Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you very much for your testimony. I appreciate the information that you shared. Kind of piggybacking along the lines of questions that Commissioner Messner just noted, given that you're mentioning the equipment and et cetera to address some of these concerns is a concern for you. I think Commissioner Messner was also trying to get at the concerns about rigs that are just coming in just for the continued operations, et cetera. And I'm curious if you could comment on kind of the disturbance, when the pad went in, if you have some knowledge of that area and the wildlife movements in the area versus what they are now, and whether the equipment that's coming in for just normal operations and snow removal, et cetera, is, how that relates to equipment that would come in for some of these erosion and stormwater control measures.
Sure. I guess I'd answer that in kind of a twofold. The first one being that I think all of us recognize that there are disturbances when we come in and drill a pad. That's why we have our wildlife mitigation plan. That's why we're doing compensatory mitigation. That's why we do a holistic management of the whole ranch so that our positive impacts are better than the negative impacts. And so, in my opinion, as a landowner, we've already made the initial disturbance. We know we're going to do a final reclaim and do a final disturbance. And that's all important. By adding an additional third disturbance to the area, we're actually increasing our disturbances. We're increasing our impacts. Now, as BJ said, if there was substantial issues with the site in a risk of environment, then yeah, it would definitely warrant the benefits would outweigh the negatives. And so we would want to fix that. In this situation, it's a stabilized area that is not disturbing anything, wildlife or major risk for environment. And so I don't believe those additional disturbances are warranted. And as far as the current traffic, these pads are about 3 miles behind a security locked gate that is 24 hours of 24/7 surveillance. It's very minor traffic in this valley. The wildlife is used to the current level of traffic. Essentially 1 or 2 people a day during the week go through there. Those livestock and the livestock and the wildlife has adapted and is happy there. They have the ability to go anywhere in this landscape they want to go, and they're choosing to be in this valley where it's at. My concern is the additional amount of traffic, the additional amount of dust, the risk of vehicle strikes on animals, the risk of introducing more noxious weeds. The increased human element, in my opinion, does not warrant the benefits of another reclaim.
Thank you.
Any other questions? All right, I'm seeing no further questions. Thank you, Mr. Andrews, for your testimony this morning. Mr. Neslin, does that conclude your case in chief?
Chair Robbins, yes, that concludes our case in chief. Could I ask Ms. Larson for a time.
Yeah, why don't we get a time check for both sides?
Yes, so Karis has 22 minutes and 14 seconds remaining. Staff has 1 hour, 42 minutes and 52 seconds remaining.
Okay, with that, I would suggest we take our morning break. Let's break until 10:47, and that'll give us 15 minutes. And during that time, Mr. Kirshner, if you want to get your witnesses up to the panel, that would be great.
Yeah, thank you. Hearings Manager Larson, we're going to need Dr. Denise Arthur and Aaron Trujillo for the next session.
All right, welcome back, everybody. This is Colorado Oil and Gas Conservation Commission. We're continuing our hearing on the Karis matter. I believe now we will hear from Mr. Kirshner and his witnesses.
Thank you, Chair Robbins. Thank you, Commissioners. Once again, my name is Steve Kirshner. I'm going to be presenting staff's response to Karis's application. So for a brief overview, in our presentation today, we're going to start by talking to Dr. Denise Arthur about some specifics on the reclamation team and the rules at issue here. We're then going to go on to talk about the history of these locations, the completed reclamation prior to the oil and gas disturbance, and how that plays into staff's determination about compliance with these rules. You're going to hear extensively from Aaron Trujillo. He's the reclamation inspector who performed the inspections and assigned the corrective actions that are at the heart of this matter. And finally, once again with Dr. Arthur, we're going to go into detail over Karis's request for a surface owner waiver from Rule 1003 and a variance from compliance with Rules 1002F and 1003. So with that overview, I'd first like to call Dr. Denise Arthur. Hi, Dr. Arthur, can you hear me?
Yes, I can.
Okay. Can you state your name?
My name is Dr. Denise Arthur.
And what is your title with the commission?
I'm the Reclamation Supervisor for the state of Colorado.
Can you talk a little bit about your educational background and your experience before you came to the commission?
Yes, I have a bachelor's degree in environmental population organistic biology from the University of Colorado at Boulder and a doctorate in rangeland ecosystem science with an emphasis in restoration ecology from Colorado State University, Fort Collins. I've been working in the field of reclamation, restoration, and environmental management for 34 years.
Thank you. And how many years have you been with the commission? And can you briefly describe your experience with the commission culminating in your current role?
Yes, I started in 2014 with the commission. One of the retired field managers, field inspection managers, realized that the commission would benefit from having a dedicated staff with specific education, experience, and expertise in restoration and stormwater to address the 1000 series rules. I was hired to build that staff with that expertise so we could address the issues associated with ecological assessments, wildlife habitat, vegetation, reclamation, stormwater, even looking at wetlands occasionally. And as the supervisor, my role entails addressing ecological and reclamation issues associated with the rules. I look at the new rules, the old rules, developing guidances, conducting variance assessments, and I manage a staff of 6.
Speaking of that staff of 6, can you just tell us a little bit generally about what the reclamation team does?
Yes, what we have at Cogcc are several groups with expertise in a variety of different focus areas. For instance, we have the environmental group, we have the reclamation specialists and field inspectors. So the reclamation team, with their expertise, they focus on locations, reclamation, stormwater. They assess compliance with permit conditions. They look at soils, they evaluate flora and habitat. They can do vegetation assessments by species and including looking at weed infestations. And they assess a location for final reclamation for bond release. They respond to reclamation related complaints and look at all 1000 series rules and any other ecological issues that might arise concerning the rules. This is in contrast actually to the field inspectors who focus on different aspects of oil and gas rules. Their main focus is the oil and gas process flow and safety. Primarily, they're looking at oil and gas operations and focus on drilling and completion operations. They look at production equipment, equipment integrity. They observe gauges, they observe MITs, cementing, they witness Bradenhead tests, etc.
So you've heard Karis mention that there were previous inspections at these locations. I want to briefly discuss those previous inspections in light of what you told us about the reclamation staff versus the field staff. Were any of the previous inspections before 2021 conducted by these specialized reclamation inspectors?
No, they were not.
And Karis noted that in some of these inspections, the field inspectors may have noted various issues with the 1000 series rules, but at other times they may not have remarked on issues related to the 1000 series rules. Is it unusual for a field inspector to flag something related to reclamation if they happen to notice it on site?
No, it is not.
And then specifically related to stormwater, because Karis did mention this in his testimony, does the fact that some of the prior inspections by these field inspectors didn't specifically notice issues with the BMPs, does that mean that those stormwater BMPs were adequate in perpetuity?
No, it did not. Stormwater management needs to be planned, installed, implemented, and maintained for good engineering practices. And part of that is not the fact that these stormwater issues are static. Stormwater is an ongoing obligation.
Okay, I'm going to share my screen. Can you see that the PDF that I'm showing?
Barely.
Okay. Dr. Arthur, can you generally explain to the commission the requirements of Rule 1002F2 as it relates to stormwater protection?
Yes, inspectors look for erosion issues, including rill erosion, gully erosion, sloughing that may be occurring. They observe bare slopes that are not stabilized. They look for the site degradation. They observe BMPs that may not be installed properly. They might not be functioning. They may have maintenance issues, as well as looking for BMPs that are conducted and maintained per these good engineering practices.
You referred to these BMPs and you referred to maintaining these BMPs. Would you describe the stormwater obligation? Would you describe this as an ongoing obligation?
Yes, absolutely.
So in light of this, is it unusual for one inspection not to find a violation of 1002F and then a subsequent inspection to find a violation?
No, that would not be odd. No.
Okay. You referred a little bit to erosion earlier. Can you just generally describe to the commission some of the potential impacts that can occur from erosion?
Site degradation, other adverse impacts to wildlife and plant communities.
Can you be a little bit more specific? How can erosion affect wildlife habitat on a location itself? So not necessarily considering runoff.
So erosion control, both wind and water, can affect large and small fauna. These ecological systems are integrated and connected. Therefore, erosion could affect these small invertebrates, reptiles, rodents. By removing habitat cover for predator, refugees, for food sources, pollinator species availability. For large fauna, erosion can lead to lack of vegetation, potential food resources, and remove other habitat resources like birthing sites. When it comes to avian species, nesting sites could be removed. In addition, wind and water could affect aquatic macroinvertebrates in the creek below these locations. Wind and water or wind erosion can deposit soil particles on the vegetation that would potentially wash and go off-site, that could be deposited in the creek, which could affect the fish species, food sources, and spawning sites.
Thank you. I want to turn now to the other rule that we've talked about here. This is Rule 1003. The portion of the rule at issue here revolve around an operator's obligations to reclaim portions of a location that are unneeded for production, and that's 1003B, and an operator's obligation to revegetate disturbed areas that are no longer needed for production, that's 1003A. E. I want to talk first about Rule 1003B. Can you tell us briefly what this rule requires of operators?
This rule requires operators to reclaim all areas not needed for production.
And I'm going to quote briefly from the rule. It states that areas reasonably needed for production operations or for subsequent drilling operations to be commenced within 12 months shall be compacted, covered, paved, or otherwise stabilized and maintained. I'm going to move to Rule 1003. Oh, excuse me. When we look at this rule and speaking about those prior inspections, does the fact that the prior inspections by field inspectors may not have noted that Caris failed to reclaim those unused portions, does that mean that they were in compliance with interim reclamation rules?
No, not necessarily, no.
And can you tell the commission why it's important for operators to reclaim these areas that are no longer needed for production?
Well, it's our obligation to protect and minimize adverse impact to public health, safety, welfare, the environment, wildlife resources. Additionally, our obligation also is to protect adverse environmental impacts, air, water, soil, biological resources resulting from oil and gas operations. And many of these protections can be achieved through reclamation of the land.
Thank you. And just speaking generally here, what are some signs that reclamation inspectors might look for when determining whether these areas have been properly reclaimed?
We use a visual on the ground evaluation. We look for whether the location is properly recontoured. Is there established desirable vegetation? We look for uniform vegetation. We may also assess whether germination is occurring to look at whether that habitat and that seeding would become successful. We look for weeds. We do a visual assessment of the placed soils in any topsoil that might be placed. Reclamation specialists may also use drones. We have some licensed reclamation specialists that use drone equipment to provide like a visual analysis of the reclaimed areas versus the production areas.
Thank you. I want to talk about Rule 1003E now. Should be on screen here. Can you tell us what Rule 1003E requires of operators regarding revegetation?
So it requires a revegetation of 80% of pre-disturbance or reference areas. And the reason we have this rule, or this rule was put into place, is because successful perennial revegetation ensures that there's a long-term self-sustaining plant community that functions to protect the land and as a resource for wildlife and other biological resources. How we measure whether that has occurred is through looking at the vegetation cover analysis. When we say plant cover, we're talking about the established vegetation and its foliage that resides above the ground. The analysis looks at whether the vegetation is 80% of a reference area. The operant word here is of. So if there's a vegetation cover in a reference area that is 40%, then within the reclaimed areas, the vegetation cover would need to be 32%. And this is desirable species, not weeds. Reclamation specialists are well versed in plant identification and make observations in the field as to whether the vegetation is met or is progressing toward meeting the reclamation standards. And if not, then a corrective action is issued.
Thank you. Can you talk a little bit about the discussion in the rule about how disturbed areas meet interim reclamation? Now, as we saw earlier, 1003B requires that areas that would be needed for production be compacted and stabilized. 1003E lets us know what to do with areas that are no longer needed for production. So can you help us understand which areas each of these things applies to?
Well, when we talk about the rules, there are two areas that we're talking about. We're talking about a total disturbance, whether that interim reclamation is complete. So it talks about total disturbance, which includes both production areas and interim reclamation areas. In the definition of these two different areas within a total disturbed area was clarified in the 2017 NTO. So reasonably needed for production areas are those that are immediately around preset conductors, wellheads, production tanks, etc. And then there is a clarification in the NTO that talks about, we're talking about looking at interim reclamation on production areas. The production areas require stabilization, maintenance of the area, compaction, covered, paved, or other methods to minimize dust and erosion. And then the interim reclamation on lands other than the production areas requires the establishment of a uniform vegetation cover.
Thank you. And can you briefly and generally tell the Commission why it's important for operators to conduct this revegetation?
Well, I think I might have answered that some above as well, but it's our obligation to protect and minimize adverse impacts. Additionally, it's our obligation also to protect against adverse environmental impacts to air, water, soil, biological resources, again, resulting from oil and gas operations. Some of these protections are achieved through the reclamation of the land.
Thank you. And just briefly, when reclamation inspectors are assessing the vegetative cover in an area, would they use something like an aerial photo to help them determine what the area looked like before the oil and gas disturbance?
Yes, we review historical aerial photographs. It's one of the tools we use when we go out to a location or prior to inspecting a location.
Thank you. I'm going to turn to the history of these locations now. Can you, have you had the opportunity to review the details of these locations?
Yes, I have.
Thank you. And prior to being disturbed by oil and gas operations, what was this land used for?
This land was used for a mining operation, Union Oil of California, Unical.
I'm going to show you what's been marked as Staff's Exhibit G. This is page 58 of Staff's exhibits. Do you recognize this document?
Yes, I do.
Can you tell the Commission what this is?
So now it's DRMS, and this is a document that they had in their file from Unical showing where their mining operation was.
Okay. I'm going to move my pointer over what's been labeled on the document as the East Fork disposal area. Is that where the oil and gas locations we're talking about today are currently located?
Yes.
Okay, thank you. I'm going to show you Staff's Exhibit J. This is at page 107 of Staff's exhibits. Do you recognize this document?
Yes, I do.
I'm going to make this as big as I can.
That's okay.
What is this document?
So this is now DRMS. It's their mining and safety inspection report.
Okay. So I'm looking at the document here where it states East Fork disposal area. And as you just told the Commission, this refers to the area where the oil and gas locations are now situated. I'm going to read from that document briefly. It says the spent shale disposal area is located in the valley of the East Fork of Parachute Creek, north of the creek and along the south flank of Long Ridge. The spent shale was covered with a minimum of 4 feet of soil and seeded. As noted in numerous inspection reports, an excellent cover of vegetation has become established on the spent shale area. Numerous grass species such as wheatgrasses, wild rye, fescues, Indian rice grass, and bluegrasses have become established. Legumes noted include clovers, alfalfa, and cicer milkvetch, rabbitbrush, big sagebrush, and saltbush are also present in the area. Now, Dr. Arthur, when you read that the spent shale was covered in 4 feet of soil and seeded, and that, quote, an excellent cover of vegetation was established throughout the spent shale area, what does that tell you about the potential for revegetation and reclamation at this location?
The potential, it's very possible to revegetate unused portions of these locations with successful perennial vegetation cover.
Thank you. I'm going to show you another portion of Staff's Exhibit G now. This is page 57. Try and zoom into this one as well. Do you recognize this?
Yes, I do.
Can you tell us what this is?
This is a letter that was in the file from DRMS that shows that Unical's $12 million bond was released.
Okay. I'm going to read a portion of this document as well. The division staff wish to commend Union Oil of California for its reclamation efforts and the resulting success. This document also notes that, quote, the financial warranty is released in its entirety. Dr. Arthur, when you consider that when the state released Unical's bond, it did so in its entirety. I'm speaking as a reclamation professional. What does that tell you about the quality and the completeness of reclamation prior to the oil and gas disturbance?
This shows that the reclamation was successful and complete.
I'm going to show you one more exhibit now. Do you recognize this photograph?
Yes, I do.
Can you tell us what this shows and what the yellow stars represent?
So this shows the East Fork mining area, and it is an aerial from 2005. And those yellow stars show where the current subject well sites are.
Thank you. And is this photograph dated prior to the oil and gas disturbance?
Yes, it is. The photo that we're looking at is 2005, and the disturbance for these locations, I believe, began in 2006.
Thank you. And when you look at the vegetation cover in this photo, what do you observe?
I observe a uniform cover of vegetation throughout the location, and the report shows what species were likely there.
Thank you. So Dr. Arthur, based on the the aerial photos, based on the state inspection report stating that the locations had an excellent cover of vegetation, and based on the fact that the state released the mining company's bond in full following that reclamation, how would you characterize the reclamation and the status of the site prior to the oil and gas disturbance?
It shows that it was fully reclaimed with soil and perennial vegetation.
Thank you, Dr. Arthur. Chair Robbins, I have no further questions for Dr. Arthur at this time.
Thank you. Cross-examination for Karis.
Yes, give me just a moment. Chair Robbins, and collect my thoughts. Good morning, Dr. Arthur. Pleasure
morning.
to see you again.
Yeah,
You testified that you started with the commission in 2014. Is that right?
that's correct.
And that would have been about 6 years after the last rulemaking that substantively addressed the 1000 series rules. Is that correct?
Yes,
And you were not involved in that rulemaking. Is that correct?
I was not.
And you testified that you developed the reclamation group. I take it that took some time to bring your staff together for this purpose.
Yeah, it took some time hiring. We were definitely up and running in 2014.
Okay. Before that time, did the field inspectors inspect sites for interim reclamation and stormwater?
I believe there was some, yes, looking at reclamation.
And I'd like to show you excerpts from Karis's Exhibit 7. And I'm going to ask my colleague, Mr. Goltz, to bring them up on the screen because he's much more technically adept than I am. That may take a minute. Dr. Arthur, do you recognize this letter?
Yes, I do.
And you received a copy of it. You were copied on it, as I recall.
Yes.
And did you respond to Karis regarding this letter?
Chair Robbins, I'm going to object. This is outside of the scope of Dr. Arthur's direct.
I'm going to allow the inquiry. We generally allow information in to help us understand what's going on. So go ahead, Mr. Neslin.
I would add that I'm going to be asking Dr. Arthur about these communications, but I think for now, but that's fine.
I think my question, Dr. Arthur, was, did you reach out to Karis regarding this letter?
No, that's not staff protocol. When a letter goes to the commission or something comes in from a lawyer, my staff and myself do not respond.
If I could just clarify the record here, Mr. Goals, could we go to the last page of this? This letter was not submitted by a lawyer for Karis. It was submitted by their regulatory manager.
It was submitted to Julie Murphy.
Correct.
So
And-
I would not respond to a letter directed to Julie Murphy, the director of COGCC.
And then could we go to, I'm going to ask to go to page 14 of our petition, the application. Dr. Arthur, I'm going to represent that this is the last page of the application that Karis submitted. I believe you reviewed this.
Yeah, I'm trying to figure out where we are. Yes, I reviewed the exhibits.
And this
Mr.
is
Nesson,
the,
I was just going to say, can you lay a foundation? What is this document we're looking at?
this is the Karis's application that initiated this proceeding.
Okay, I just
It
want to make
is-
sure, Ms. Arthur, does that correlate with your understanding?
Yes.
Chair Robbins, once
It-
more, I'm going to renew my objection here and state that as we laid out in our reopening, we're going to talk to Dr. Arthur directly about the request for a variance and surface owner waiver. I would submit that, this line of questioning at this time is untimely.
Mr. Neslin, do you want to wait until after she testifies on direct and then go into this area of inquiry, since we now know that's where they're going to go?
That's fine. We can take this up subsequently.
Why don't we do that, and it'll help sort of streamline
Certainly.
this process.
Whatever we can do.
Thank you. And Mr. Kirshner, as Mr. Neslin is regathering his thoughts, from what you stated, it appears you're planning on recalling Ms. Arthur as a direct witness.
That's correct. So just to kind of give the commission a picture of what we're thinking here, we wanted to organize our testimony. We're going to talk about the site history and the inspections first, which we've done. We'll next call Mr. Trujillo to talk about the 2021 inspections. Obviously, questions related to those inspections will be appropriate at that point. That kind of summarizes Karis's request for what it calls the declaration of compliance. We wanted to address that before we address the request for a variance. But I can assure the commission that Dr. Arthur is going to go into detail later about the request for a waiver and a variance. We simply wanted to make sure we're organizing our presentation in the same way that this application and our petition is organized.
Okay, thank you for that explanation. Generally, when someone calls a witness, they sort of go through all of that witness's information in one fell swoop. So I can understand, Mr. Neslin, that your thought process in terms of going into what you felt was important. But with that understanding, Mr. Neslin, are you comfortable at addressing the cross as to what's been testified to so far, and then you'll get another shot here in just a bit?
Director, I'll reserve the rest of my cross then.
Okay.
For Dr. Arthur. And understanding that there is likely to be some overlap back and forth between these different areas of her testimony.
Yeah.
But we can move on.
Okay. All right, so I think we're done with the abbreviated cross at this point. Do you have any redirect, Mr. Kirshner?
I do not.
Okay, then why don't we move on to Mr. Trujillo as your next witness, and then we'll look forward to hearing from Ms. Arthur or Dr. Arthur again toward the conclusion.
Thank you. Give me just a moment to pull up some of my information here. Okay. Thank you. Could you state your name for the commission?
Aaron Trujillo.
And could you tell us your title?
I am the Northwest Reclamation Specialist.
And Mr. Trujillo, could you tell us a little bit about your educational background and your experience prior to coming to the commission?
I graduated in 2008 with a bachelor's degree in wildlife biology from Colorado State University. Since then, I have worked for multiple state and federal agencies within Colorado and Wyoming in positions ranging from wildlife management, wildlife enforcement, and habitat evaluation and restoration.
And how many years have you been with the commission? Can you kind of just describe your role with the commission?
Yeah, I have been with the commission since 2015. I was originally hired as the Northeast Reclamation Specialist and transferred into my current role as the Northwest Reclamation Specialist at the end of 2019. During my time, I have received multiple stormwater certificates, including certification as a qualified stormwater manager. I also hold a FAA Part 107 remote pilot certificate that authorizes me to pilot small unmanned aerial systems or drones within my position for the commission. As a reclamation specialist, I am involved with an oil and gas location from the initial construction to its final abandonment and bond release. During initial construction phases of a location, a reclamation specialist will conduct a pre-drill stormwater inspection to document compliance with stormwater requirements and Form 2A permit requirements and conditions. We also evaluate the topsoil on the location and determine if it has been properly salvaged, stored, and protected for future reclamation. After construction and drilling operations have been completed, reclamation specialists will then perform an interim reclamation inspection, where we will determine whether or not areas not reasonably needed for production have been reclaimed in accordance with the 1003 interim reclamation rules. After a well on a location has been plugged or abandoned and the location is no longer active, reclamation specialists will perform a final reclamation inspection to determine compliance with the 1004 final reclamation rules. We will document whether or not all surface equipment have been removed, that remediation projects have been closed, if there are any existing variances, or like with interim reclamation, we will evaluate if compaction alleviation, recontouring, regrading, replacement of soils, revegetation activities have been performed. During any reclamation inspection, we will also look at the stormwater management on a location to determine if best management practices have been implemented and maintained in accordance with the stormwater rules. For final passing for reclamation, reclamation specialists will evaluate the vegetation establishment to determine if the areas have met Cogcc revegetation standards, and we may use tools such as a drone or vegetative transects to make a determination. As I've mentioned, the primary focus of my position is to conduct reclamation and stormwater inspections on oil and gas locations. Since 2015, my duties have also expanded to include working on various enforcement projects, collaboration with my regional environmental protection specialists regarding remediation projects, orphan well projects, new rules, guidance documents, and variance requests, just to name a few.
Thank you. Do you have a kind of an estimate of about how many reclamation inspections you perform per year?
I have performed approximately 3,900 reclamation and stormwater inspections, or roughly 650 a year.
Thank you. And have you visited the two sites that we're describing?
I have.
Okay. I wanted to start with the H29A. That's location ID 335594. I'm going to share my screen. I'm showing you what's been marked as Staff's Exhibit C. This is page 17 of Staff's Exhibits. Do you recognize this document?
I do.
Can you tell us what this is?
This is my March 9th, 2021 stormwater and reclamation inspection.
And in this inspection, did you cite CARES for violations of Rule 1003B, 1003E?
Yes.
I want to first talk about Rule 1003B. That rule requires operators to reclaim areas no longer needed for production. Dr. Arthur did go over this in detail, so can you sort of briefly describe how you assess compliance with this rule?
Yep, so these are areas on a location that were disturbed or affected during construction or drilling operations, where equipment such as wellheads, production tank separation equipment have not been installed. This also includes areas that are not required for vehicles and equipment to safely access and perform required operations.
Thank you. And then Rule 1003E, this rule requires revegetation, as we discussed. Can you once again briefly describe how you assess compliance with this rule?
Yes. I initially start with a visual evaluation. Is the vegetation establishing a desirable perennial species on non-cropland locations? Are there areas where uniform vegetative establishment is not occurring, and are noxious weeds prevalent? A reclamation specialist may use drone equipment to help provide a visual analysis of the reclamation areas and may conduct vegetation and or germination transects.
Thank you. I'm going to show you Staff's Exhibit G. This is page 61. Do you recognize this photo?
I do.
Can you tell us what this is?
This is a 1990 Cogcc aerial image. This photo is showing the oil and gas locations and wells prior to oil and gas disturbance.
And briefly, to the extent that you can, how would you characterize the vegetation cover?
Vegetation cover appears to be uniform and intact.
I'm going to show you another photo. This one is the one we showed to Dr. Arthur. She told us this is also before the oil and gas disturbance. These two stars represent the oil and gas locations. Does the vegetation cover here look similar to you?
It does.
Okay. I'm going to show you another aerial photo. This is Staff's Exhibit G. This is page 66. There we go. Do you recognize this photo?
I do.
Can you tell us what this shows?
The larger photo is a 2017 USGS aerial imagery. The bottom left photo is a 1993 Google Earth insert. The photos show the location's disturbance post-construction, and it appears to be during drilling operations.
And can you just characterize the contrast between the inset photo and the main photo?
Yes, the photo again on the left shows the areas where the location exists prior to oil and gas disturbance. The photo on the right now shows the areas after oil and gas disturbance has occurred.
And how would you characterize the difference, let's say, in the area where my pointer is now?
Those areas, the vegetation appears to have been removed. It appears to have been compacted and part of the disturbance area for the location.
Thank you. I want to talk first about your visit to the site on March 9th. This is page 26, Staff's Exhibit D. Do you recognize this photo?
I do.
What does this photograph show?
This photo was taken on this photo was taken from the south end of the H29A facing approximately northwest. This photo is a part of a series included in my inspection report that provides an overview of the location as a whole.
Okay. This is page 27. Can you tell us what this shows?
A continuation of the prior photo. I'm on the south end of the location. I'm now facing north or northwest. Again, showing an overview of the location as a whole, but this is also showing areas that I identified in my inspection as areas not reasonably needed for production where the equipment is located.
Okay. And then can you tell us what this photo shows briefly?
Again, a continuation of the prior photos. I am now facing approximately northeast. In this photo, you can see the wells on the H29A. In the background would be the remediation project. On the right of the photo would be additional equipment.
I'm going to skip here to page 30. Can you tell us what this photo shows?
This photo was taken.
Go ahead, sorry.
Yep, this photo was taken from the north end of the location, showing the slopes of the disturbed areas.
And then just speaking purely to 1003 in terms of revegetation, what does this photo show?
I would not say that the vegetation here would be uniform.
Okay. This is Staff's Exhibit D, page 25. Can you tell us what this photo shows?
Yes, this is a 2019 Cogcc aerial image. that was included in my inspection report, identifying areas that are not reasonably needed for production that I had required reclamation pursuant to 1003 rules.
Thank you. And when you assess locations for compliance with Rule 1003, do you regularly review aerial photos from before and after the disturbance?
More often than not, yes.
Based on your observations on March 9th, including the photographs that you took here, did you cite Caris for a failure to comply with Rule 1003?
I did.
Did you issue Caris a corrective action related to that rule?
I did.
Can you summarize that corrective action?
Comply with 1003 rules, conduct reclamation on areas not reasonably needed for production.
Did you also require revegetation?
I believe so.
Okay. Did you return to the site after your March 9th inspection?
I did.
I'm going to show you another photograph. This is Staff's Exhibit H, page 88. Can you tell us what this is?
Yes, this is an image taken with use of a drone to get an updated image of the location as a whole. The blue polygons that you can see in the photo are, again, approximate areas identified that do not appear reasonably needed for production.
And then where my pointer is here on the western portion of the location, how would you characterize the vegetative cover there?
Not uniform. These areas were mostly compacted and gravelled.
And I just want to reiterate, this area now where I'm showing you on the northeast corner of the location, this is what's been characterized as the remediation area. You're not asking that Caris reclaim this area at this time, are you?
I am not.
Okay, thank you. This is page 89. Can you tell us what this shows?
This was photos included in my follow-up July 22nd, 2021 inspection. I am taking the image from the south end of the location facing northwest. The photo is showing areas that I designated as not reasonably needed for production that I had required reclamation.
Thank you. Same question. Can you just tell us what this shows?
Again, south end facing north. Photo again is showing areas that I identified in my previous inspection as areas not reasonably needed for production that I required reclamation pursuant to 1003 rules.
One more time, can you tell us what this photo shows?
This photo was the very western disturbance area that you identified as kind of a triangular area. These were also areas identified as not being reasonably needed for production within the disturbance area.
Finally, this is page 97, Staff's Exhibit H, or at least it will be. There we go. Can you tell us what this photo shows?
Yes, these photos show noxious weeds that were observed on the location. The photo left shows halogeton establishments on the compacted paved areas. Photo right shows examples of musk thistle that was observed on the location.
And what are an operator's requirements for revegetation regarding noxious weeds?
They are required to manage for noxious weeds.
So given what you saw on site and what you documented in these photographs, as of your visit to the site on July 22nd, was Caris in compliance with Rule 1003 at the H29?
No.
You've heard Caris allege that the unused portions of the H29A have in fact been revegetated. Given everything we've seen here, excuse me, I need to pull something else up. One moment. Okay. Excuse me, Mr. Trujillo, can you see this photo?
I can.
Caris has pointed to this photo in its testimony, and it alleges in its application, its pre-hearing statement, that the unused portions of the H29A have in fact been revegetated. Can you describe what we're looking at here specifically as it regards revegetation?
This photo, I believe, is taken from the southeast end of the H29 facing northwest. Appears to be highlighting areas on the slopes where I had identified as areas of concern in regard to both reclamation and stormwater.
Does this photo have any relevance to your determination on March 9th and July 22nd that Keras was out of compliance with Rule 1003 at the times that you visited the sites?
No.
Have you reviewed Keras's exhibits that it submitted with its application and its pre-hearing statement?
Yes.
Did you see in those exhibits any photos that would change your determinations made on March 9th or July 22nd regarding reclamation and revegetation?
No.
And can you tell us, in order to make a determination like that, what would you need to do?
I would need to perform a follow-up inspection.
Can you tell us why it's important to reinspect locations versus simply reviewing photographs?
Yes. Pursuant to 1003 rules, operators are required to perform work such as compaction alleviation, recontouring, regrading, replacement of soils, and revegetation. Much of this I cannot confirm with just photos.
Thank you. Have you received any forms or any notifications from Keras about any additional work being performed at these locations on interim reclamation or revegetation?
No.
Okay. I want to talk next about Rule 1002F. This is staff's exhibit D, page 30. We previously established this was taken March 9th, the date of your inspection. Speaking to stormwater, what does this photo show?
This photo was showing areas that I observed with loose, unstabilized soils as a result of oil and gas disturbance. This photo also shows upslope areas where an incision is occurring, such as a head cut.
Is that where I have my pointer now?
Yes, that would be an example of what I observed.
Okay. Do you believe that this disturbance predated the oil and gas disturbance?
No, I do not believe so.
And how do you know that?
By review of the historical aerial imagery.
Thank you. I'm showing you page 31 now. Can you tell us what this photo shows?
Again, this is taken from those slopes on the north end of the location. I am documenting observed areas of concern where I witnessed unstabilized soils and upslope incisions.
Thank you. Based on your observations on March 9th, including what you saw in these photographs, did you cite Keras for a failure to comply with Rule 1002F?
I did.
Did you assign a corrective action?
I did.
What was that corrective action?
I believe it was to comply with Rule 1002F, implement stormwater and erosion control measures in accordance with good engineering practices.
I want to look at some photos from your follow-up visit. This is staff's exhibit H, page 91. What does this photo show?
This photo was included within my follow-up inspection. This is showing the unstabilized slopes or areas of concern that I had previously identified in my prior inspection. What I am observing here is that I am not, do not appear to see any evidence that additional control measures have been implemented to stabilize the slopes in order to minimize erosion and degradation.
Thank you. So bear with me, I'm going to show you one more of Keras's exhibits. Just have to pull that up. Okay, I'm showing you Keras's exhibit 15. I believe this is page 203. We've discussed this photo previously with Keras, but it's been marked as being from July 29th, 2021, 1 week after your visit to the site. Can you describe what you see here?
It appears that additional work has been taken by the operator on these slopes where I identified as areas being of concern.
And did you observe any of this additional work during your July 22nd inspection?
No, I did not.
Thank you. Based on Keras's presentations, based on everything you've reviewed, including your on-site visits, can you tell whether when Keras took its photos, was the site in compliance with Rule 1002F?
I am unable to make that determination based off of the photos. I would need to perform a follow-up inspection to confirm that.
Okay, thank you. I want to move to the D28 Wealth Site now. Now, as Keras described and as we've discussed, you visited that site on March 9th. I'm going to show you staff's exhibit E. This is page 40. Let me share my screen. Do you recognize this document?
I do.
Can you tell us what this is?
This is my March 9th, 2021 stormwater and reclamation inspection on the D28.
In this inspection report, did you cite Karis for a violation of Rule 1003?
I did.
I'm going to show you staff's exhibit F. This is page 47. Can you tell us, in terms of revegetation, can you tell us what this shows?
This photo is taken from the northwest and location facing northwest. This is an overview of areas where I identified areas where vegetation was not progressing towards a uniform standard, where also erosion concerns had also existed.
Thank you. This is page 49, speaking to revegetation. Can you tell us what this shows?
This photo again was taken from those slopes observed in the prior photo. What I am showing here is areas where uniform establishment was not evident, as well as stabilization concerns existing.
One more. This is page 50. Can you tell us what this shows?
Again, taken from the slopes as observed in the prior photos, but now I'm facing approximately west. Again, this is showing slopes where I observed uniform establishment was not evident, as well as stabilization concerns existing.
Thank you. Based on your observations on March 9th, including these photographs, did you cite Karis for failure to comply with 1003?
I did.
Did you require Karis to comply with Rule 1003 and establish uniform vegetation cover?
I did.
And did you return to the D28?
I did.
Can you tell us when that was?
In July of 2021.
I'm going to show you staff's exhibit I, page 105. Do you recognize this photo?
I do.
Can you tell us what this shows?
This is my follow-up July 22nd, 2021 inspection. This photo was taken from the slopes on the north end of the location where I had observed areas of stabilization and revegetation concerns.
Thank you.
Specifically, this photo is documenting that I was unable to observe any evidence that corrective action has been addressed in terms of implementation of control measures or revegetation.
So given what you saw on site and what you documented in these photos, based on your expertise and your experience, as of July 22nd, 2021, was Karis in compliance with Rule 1003?
No.
Okay. Give me one moment. I'm going to pull up one more exhibit. I'm showing you exhibit 9, page 157 of Karis's exhibits. Can you identify the location in this photograph?
This photograph appears to include the slopes of the D28.
Okay. And Karis has pointed to this photograph as evidence that it is in compliance with Rule 1003. Can you tell us what this photograph shows?
I believe it is showing an overview of the interim areas. It also appears to show areas where operator has conducted additional work as indicated by the lighter green in the upper slope region. I believe Karis said that they had hydromulched this area.
And was this work done after your July 22nd visit to the site?
I believe so.
Did you receive any notification or any forms related to this work?
No.
Speaking more generally, when you reviewed Karis's exhibits, when you heard their testimony, have you seen photos that describe each of the areas of concern that you identified in your inspections?
I believe that their photos included some of my areas, but they did not generally focus on the areas that I specifically identified as areas of concern.
So based on your expertise and your experience, as well as everything you've seen and heard in Karis's materials and presentation, can you say whether Karis is currently in compliance with 1003 at the D28?
Again, I cannot. I would need to perform a follow-up inspection.
Thank you. Let me show you staff's exhibits one more time. This is page 45. I want to turn back to the March inspection for the D28. Did you cite Karis for a violation of 1002F related to stormwater?
I did.
Okay. We're going to scroll down to page 47. Can you describe this photo again, this time looking at it through the lens of stormwater controls?
Yes, so again, this photo is identifying the slopes on the northwest end of the D28. This is including an overview of areas that I identified as areas of concern in regard to stormwater.
Okay. I'm showing you page 50. Can you describe this photo specifically related to stormwater?
Yes, again, this is the slopes of the D28 where I identified unstabilized soils and missing or insufficient stormwater and erosion control measures to minimize erosion or degradation.
This is page 51, same question.
This photo was taken from the stormwater diversion ditch on the northern perimeter of the disturbance area for the D28. This photo is showing the slopes of the ditch itself where soils have been unstabilized or unconsolidated, as well as incisions in head cutting that I can observe.
Okay. So based on your observations, including these photographs, did you cite Karis for a failure to comply with 1002F?
I did.
Did you assign a corrective action?
I did.
Can you tell us what that was?
Comply with 1002F.
You visited the sites again in July. Let's look one more time at Staff's Exhibit I. Speaking to stormwater concerns, can you tell us what you see here?
Again, this is taken from the stormwater diversion ditch along the north end of the disturbance area. The photo showing here is showing that control measures in order to stabilize the soils within the ditch, as well as to address the head cut and large incisions that are forming at the top of the ditch, have not been implemented.
And just so I'm clear, where I have my pointer now, this is what you're referring to as the head cut.
Yes, it's a large incision that where erosion and degradation is evident.
Thank you. And can you describe this photo through the lens of stormwater controls?
Yes, again, this is taken from the stormwater diversion ditch on the north end of the location. I am again showing additional examples where unstabilized soils within the ditch are evident, as well as large incisions and head cut formations.
Thank you. Based on your observations on July 22nd, including these photographs, was Karis in compliance with Rule 1002F on July 22nd?
No.
Okay. Can you see this photo, Mr. Trujillo?
I can.
Can you tell us what this shows?
Again, this is the upslope interim areas of the D28.
Can you just tell us briefly what you're seeing from a stormwater standpoint?
I am seeing their perimeter stormwater ditch along the northern boundary of their disturbance area. I am also seeing the, again, green areas on the slopes where it appears, as Karis has indicated, they had implemented hydromulching.
Based on everything you've seen, including this photograph, can you say whether Karis is currently in compliance with the location with stormwater controls?
I cannot.
What would you need to do to make that determination?
Again, I would need to conduct a follow-up inspection.
Thank you. So you've heard from Karis, you've seen photos, the additional work has been done at the sites. One more time, has Karis submitted any forms related to any stormwater work at the site?
No.
Can you tell us briefly what the normal procedure is when operators do work related to corrective actions that you've assigned?
Once corrective actions have been addressed, operators are required to submit a field inspection report resolution form with an indication stating that the corrective actions have been addressed.
Okay. And if an operator believes that interim reclamation has been completed at a site, what's the normal procedure there?
Operators are required to submit a Form 4 stating that interim reclamation has been completed.
So based on your experience, based on the photos, is it possible for you to say whether Karis is in compliance with either of these rules today at either of these locations?
At this time, I'm unable to make that determination. Again, I would have to conduct a follow-up inspection on both of the locations.
And given your expertise, your experience, based on the exhibits you've seen, based on the information yesterday and today, presented by Karis and presented by staff, in the absence of a follow-up inspection, do you believe the commission should declare that Karis is in compliance with these rules?
No.
Do you believe the commission should relieve Karis of the corrective actions you assigned on March 9th?
No.
Finally, I want to turn to some things that came up yesterday. You heard Karis's witnesses describe some frustrations they have in communicating with staff. Can you kind of describe generally your process when it comes to communicating with operators after you've assigned corrective actions?
Excuse me. Yes. When I receive communication from an operator, it is more often either by email or by phone, asking to discuss the corrective actions from an inspection. If it's by phone, more often than not, I would respond requesting that the operator submit their questions in an email so that I can answer them as soon as I am able.
Do you generally prefer to communicate by phone or by email?
By email.
Can you tell us why?
I'm currently the only reclamation specialist for Northwestern Colorado, and I conduct approximately 600 to 700 detailed inspections in a year, among my other responsibilities. Phone conversations can be challenging as I am often in the field where I don't always have the resources available to properly respond. And they can also take up a substantial amount of time. I also want to make sure that I have a written dialogue of my communications and that their answers are addressed as completely as possible.
Thank you, Mr. Trujillo. Chair Robbins, at this time, I have no further questions.
Okay, thank you. I believe at this time there is an opportunity for cross-examination.
Yes, Chair Robbins, could I ask for just a very short break, 5 minutes, to organize the exhibits I'm going to want to present to the witness?
Yeah, that's fine. Let's return at 11:54.
Thank you.
Hearings Manager Larson, could I get a time check?
Yes, give me one moment.
Thank you.
Staff has remaining 52 minutes and 16 seconds.
And Secretary Larson, the petitioner?
Yes, 22 minutes and 14 seconds.
Thank you.
All right, I think we are all back together. We were going to allow Mr. Neslin with his opportunity for cross-examination at this point of this witness.
And I'll try to be brief. Mr. Trujillo, it's a pleasure to meet you.
Morning, sir.
Thank you for your testimony today. I'd like to turn you to Karis's Exhibit 7, which has been shown before, and my colleague, Mr. Goals, will bring it up on the screen. This again is the letter that Karis wrote to Director Murphy on April 30th, 2021, and I'll represent to you that you are copied on the letter. Do you recall receiving the letter?
I do.
Did you respond to Karis in any way?
No.
I would then direct you to Karis's application for declaration of compliance, or in the alternative for a variance. Did you read Karis's application?
I did.
And so this is the final page of the application, and you see some language highlighted in yellow where the application says Karis recognizes and appreciates the Commission's ongoing duties to ensure proper reclamation and promote environmental responsibility. And then skipping down, Karis would happily accept reasonable conditions of approval for a variance, such as continued compliance with Karis's WMP Wildlife Management Plan. Do you recall reviewing this?
I believe so. I do.
Did you recommend any conditions of approval for Karis's variance?
No, I have not been privy with conversation discussing a variance.
Okay. And you talked about the field inspection report response? Is that what it is? FIR?
The resolution form, yes, sir.
Resolution form. Did you ever suggest to Karis after your March inspection that they submit a form, a resolution form, a FIR?
No, these are required per our rules.
Aren't they required after corrective actions are completed?
That is
Under
correct.
Rule 210. And so if the corrective actions were not completed as they were not here, a FIR would be inappropriate, wouldn't it?
That would be correct.
Let me take you to one of the exhibits that Karis used yesterday. It was a demonstrative exhibit Mr. Middleton used in his testimony. You saw and listened to Mr. Middleton's testimony yesterday, Mr. Trujillo,
Yes,
and you recall him testifying about various equipment that would be needed for well workovers and well maintenance at the H29A wells. Do you recall that?
I do.
And those various polygons are the equipment, correct?
I believe so. I don't specifically remember what each one represents.
Do you agree that Karis will need to bring in equipment of various types of equipment for well maintenance and workovers?
I believe so. If they would need to work on the wells, then yes, they would need to bring in equipment.
And that maintenance would be needed for the production of the wells, wouldn't it?
As required.
If I could direct you to what's sometimes referred to as the triangular area to the far west. You see that area?
Yes, sir.
If we set aside the access route, which is the gray arrow, and we look only to the area north and west of that, do you know what the size of that is? A couple thousand square feet?
I cannot give an exact determination at this time. I know we've looked into it, but I cannot recall.
All right, thank you. I'd like to take you then to this is your exhibit F, photo 1. I think you testified about this previously. This photo was taken in March, correct?
Correct.
As were a number of the other photos that you testified about. Do you agree with Mr. Russell that the vegetation would be dormant in
It
March?
could be.
Okay. And if it were dormant, it would look more sparse? It would be less visible?
Likely, yes.
And could I take you then to your exhibit G, photo 2? Mr. Trujillo, I just want to correct the record if we could. Your photo here shows that it's a 2017 photograph. And I think
Correct.
you testified to that effect. But I would represent to you that the photograph shows a drilling rig and possibly frac tanks, and that the parties have stipulated that the well was drilled. The wells at this site were drilled and completed during 2006 and 2007. Could this photograph be mislabeled?
It could possibly be. I identify here that it appears to be in process.
Yeah, I mean, to your knowledge, there was no drilling activity going on in 2017, was there?
I cannot make a validation on that.
You just don't know.
No.
Then I'd like to go to your exhibit G, photo 11. That's photo 12. Here we go, photo 11. You testified, this I believe, again, is the H29A site. And you testified about the bare areas on the site, which you didn't believe met the interim revegetation requirements or appropriate stormwater BMPs. Am I correct?
That is correct.
If we could look to the left, and if my colleague, Mr. Goals, could move the arrow up to the left, there are bare areas to the left. And if we could look to the upper right, there are bare areas in other areas of the landscape on these slopes, are there not?
There are.
And those areas are outside of the location, correct?
That is correct.
So there is some of these bare areas are naturally part of that landscape, correct?
Correct.
I have no further questions of this witness.
All right. Thank you. I thank the witness for those answers. Any redirect?
Briefly, yes. Mr. Trujillo, council asked you whether you had proposed any conditions of approval for the variance after Karis submitted a hearing application. Is that something you would ordinarily do if a party submits a hearing application?
Variances prior to recent rule changes were submitted attached to a Form 4. Reclamation staff would review these, come up with a summary, and provide it to management with recommendations. Ultimately, that decision is not up to reclamation staff on approval and final approval of conditions. But yes, prior to variances being required to be submitted in a hearing, we would make recommendations of conditions. In regard to this specific hearing and variance request, there has been no discussions that I have been a part of regarding conditions of approval.
So you wouldn't do that if a party submitted this as a commission hearing application?
I would not provide conditions of approval.
Okay. And just to once again go over the rule here, Rule 502C requires that Karis provide conditions of approval for the variance. Karis has failed to do so. Have you seen in Karis's application any proposed conditions of approval?
I don't recall.
Okay. Thank you. One more thing that I wanted to touch on. I know we talked a lot about this image yesterday. You heard Mr. Neslin talking about this western portion of the location. This is one of Karis's exhibits. Once again, this blue represents the total disturbance area. The darker represents the working area. So in this image, Karis is essentially acknowledging that this area is not required for ongoing production operations. Isn't that correct?
Right, that is correct.
Okay, and I'm going to show you one more photo. You've seen this one before as well. Can you tell us what this is one more time?
Again, this is a aerial image taken with drone equipment with imposed polygon layers seen in blue, representing approximate areas identified as not being reasonably needed for production.
When you look at this, the area where my pointer is, that's the same area that was shaded in blue that I referred to a moment ago, correct?
Correct.
Okay, so it seems to you that the parties agree that this area is not needed for production.
It appears that way.
Okay, thank you. I have nothing further.
Very good. This witness is now subject to potential questioning from commissioners. Do commissioners have questions? Commissioner Messner, then Gonzalez, then Nanjapa, then McGowan.
Thank you, Mr. Chair. Thank you, Mr. Trujillo, for your testimony. That was helpful for me. I've got a few questions for you, and some of these questions are ones that I have asked previous witnesses, but I'm trying to, again, understand your perspective of the rules and your expectations regarding how the operators should comply with the rules. But the first question I have is, can you help me understand your interpretation of reference area versus adjacent area as far as determining adequate vegetation cover, adequate interim reclamation?
So a reference area would be a area of relatively similar slopes, soils, and vegetation cover prior to the oil and gas disturbance.
When you're looking at a site, your expectation is that they are utilizing a reference area or utilizing the adjacent area in determining the adequate amount of vegetative cover for interim reclamation?
Again, it would have to be a proper reference area. There are times where the lands immediately adjacent to an oil and gas location may not be an appropriate reference.
Okay. Did you hear the previous testimony from the witnesses regarding the utilization of reference areas in these particular situations?
I did.
Do you feel like the reference areas, the impacted areas that they were referencing, are appropriate reference areas for determining vegetative cover for interim reclamation in the situations that we're talking about here today?
I believe many of the examples that they provided as being reference areas were probably not appropriate. I believe many of these areas included either landslide areas, which again, I would argue is not an appropriate reference area, or areas that are similar to a landslide that was anthropomorphic, left in as a result of former mining operations.
Okay. When you're looking at stormwater best management practices, how do you determine whether the stormwater management BMPs are adequate? I mean, what are some of the things that you're looking for? What is your expectation?
Yes, so I will first off be looking for control measures to be in place. I would then look to see if they are appropriate for the site's conditions, if they have been installed in accordance with best management practices, and also maintained in a proper functioning condition. It would be my expectations that these control measures have been implemented and maintained, also in a manner that minimizes erosion, degradation, rather than facilitating or exacerbating it.
Okay, so one of your criteria is you don't want to see facilitation or exacerbation of erosion. And in determining that, does that require that some sedimentation be present in some of the stormwater management outtakes or ditches, or show some evidence of that? Or how do you determine whether that erosion is occurring?
So again, yeah, we can expect to see some erosion occurring, but what I'd be looking at is whether or not that they have control measures in place to, one, minimize erosion and degradation. In regards to my site visit, at the time of my observations, I did not observe control measures in place to minimize erosion or degradation.
Okay. So you'd indicated that there was some communication between the operator and yourself regarding these issues that we're talking about here today. Like, what type of communication typically happens between you and an operator regarding expressing your expectations for meeting the obligations of the different rules from the Cogcc, and or do you have conversations about just generally what your expectations would be for them to adequately meet interim reclamation requirements?
Yes, again, as I had mentioned, I generally would try to address their questions, but I would ask that they submit those questions in an email. Due to my workload, I am in attempts to perform my duties as a reclamation specialist. I don't always have the time or available resources in the field to properly address a lot of the concerns and questions. Therefore, I generally will ask an operator to submit those questions within an email, again, so I can have documentation of the communication and what they're asking, but then allows me time to properly respond and address their questions.
And when you're writing corrective actions for situations that you see in inspections, what kind of information do you provide in those corrective actions that creates some communication as far as expectations in order for them to be able to fully understand what they need to do to meet the requirements that you're putting forward?
So in the past, I have been commended with the amount of detail that I provide within my inspection reports, as well as my photo documentation. I try to provide specific examples showing the areas where I am trying to describe within my inspection reports. I feel that is my first form of communication with a location and an operator in regards to the violations that I observe.
Okay. And in this particular situation, was there any email back and forth as far as trying to better understand or communicate expectations for these corrective actions?
No, sir. The first communication that I recall seeing would be this letter to the director.
Okay. Thank you, Mr. Tuhil.
I think I'm being recognized, Chair.
You are.
Okay, thank you, Chair. Thank you, Mr. Trujillo, for your testimony today and for your service as a reclamation specialist.
Thank you, sir.
It's important work and we appreciate what you're doing.
Thank you.
I've got a couple questions kind of following on that last line of questions from Commissioner Messner. He had some overlap in my notes in terms of the communications in the process. And so kind of it's my understanding that you were out there, you performed your inspection, you submitted the inspection report, and it seems to me that that's kind of where the communication ended between you and Karis. Do I have that correct?
For that specific example, yes.
Okay. Yeah, and I'm focusing kind of just on this specific inspection report as to these two sites and as to rules 1002 and 1003 and the corrective actions in that inspection report. So I guess, did you have any understanding of Karis's concerns, be it, if they had someone on site during your inspection or subsequently prior to the testimony you heard from Karis's witnesses in this matter, as to their concerns about the corrective actions, their concerns about the advice they'd received from their stormwater experts, their concerns about the wildlife presence or the human impact associated with that, and their concerns about their ability to reclaim the additional lands, and we'll set aside kind of that triangular area that may be needed for the pit remediation on what I believe is the H29A pad.
Again, the only communication that I observed was this letter to the director that was submitted after my inspections. Okay.
What kind of discretion is used when applying rules 1002 and 1003 when you're on site as an inspector?
Discretion, can you elaborate?
Yeah, so you read the rules, you interpret the rules, you go out there and you apply those rules to a real life scenario, right? A real site, real circumstances that you are observing. I can't imagine that the letters and the words in that rule make it extremely clear that there is no change in your analysis or in your application there. I just can't believe that would be the case. There's got to be some nuance there. There's got to be some site specific considerations that you're reviewing and analyzing in your application of that rule. So I'm curious, that's what I mean about discretion. How are you using the specific things and what you're seeing through your eyes, and how you're applying the rule there? Kind of what's the procedure there? What's the normal practice?
Yeah, absolutely. So again, the stormwater management is site specific, and every location needs to be looked at in regard to site specific stormwater management. This is taking consideration of the size of the location, the area of the drainages both above and below the location, the soils themselves, the types of soils being sandy, loamy, or clay soils, that all takes into effect and consideration. And operators have to look at this as well in terms of what they need to decide on what is an appropriate control measure to properly manage run-on, run-off, minimize erosion degradation, site degradation, and sediment transport. In terms of my discretion, I will look to see if, again, there are control measures in place to manage erosion, degradation, and stormwater. Again, I will look at whether or not these controls have been installed per good engineering practices based off of my own training as a qualified stormwater manager. And then I would also determine whether or not that those control measures have been maintained in a proper functioning condition to, again, minimize erosion, site degradation, and sediment transport.
That's helpful. Thank you. I want you to kind of expand on that on the 1003 perspective, right? With regard to 1003F, I'm sorry, 1003 B in regards to areas that are no longer in use. And how do you determine, based on what the operator's doing and what the site needs are, what is reasonably needed for production operations or for subsequent joint operations?
Yeah, so again, these are areas where there is no equipment, no production equipment that have been installed or in place. Some indicators that I'll go by is, again, looking at aerial imagery, figuring areas beyond the production equipment, but then I'll also look on the ground. Is there vehicle traffic in these areas? Is there any indication that the operator has been using these areas for production operations? And in this situation, I observed areas where there were no equipment, no production equipment, and no evidence that operators were utilizing these areas for vehicle traffic as well.
And so, the rule itself speaks to areas for production operations or subsequent drilling operations. I don't know if it speaks in here, and I haven't read the entire rule just right now while we're speaking, so I don't recall it off the top of my head. Other projects that may be going on site, and specifically what we have here is a remediation project that's ongoing. How does that play into your inspection, your analysis on site?
Yeah, so I upon inspecting the location, I did observe that there was a remediation project ongoing. And I believe I specify within my inspection reports that we are not requiring that these areas be reclaimed, but rather once remediation has been completed, at that point, reclamation should occur pursuant to 1003 rules.
Okay. And so in your interpretation, based on what you saw out there, aside from kind of this, and I keep on using the triangular area as it's being called, over on what I believe is the west side of the location, the testimony we heard from Karis was that eastern side of the location, that central side, and of course that northeastern part where the pit was, that those are all areas that would be needed for the equipment necessary to control the wells during the remediation, for monitoring, and for I guess for the boreholes for looking at various concentrations and looking for the extent of the remediation. Do you agree or disagree with what you heard in terms of the needs for that remediation project and as it applies to this interim reclamation determination?
If I was provided more information after the submission of my inspection report regarding areas that they would need for workover equipment or remediation, it is likely that I would have had that conversation with my supervisors at management to make a more formal decision, I guess, at that point.
Okay.
This is something that has come up in the past that we've had these conversations about with operators, as well as with my supervisor and management.
Sure. Yeah, I think those conversations are super important to really understand the nuance and the site-specific considerations there. And so one thing that, I know you kind of testified that, email's preferred. It allows you to keep track of your thoughts and to keep everything documented, which I think is important. I also think a dialogue is really important, right? I think it's important that the nuance be communicated, be understood, and be chatted about, right? Maybe there's something being lost in the messaging here. And so, I can totally understand, the challenges of someone calling you when you're out on a remote site, or being able to just pick up phone calls in an ad hoc way. But I also think there's room for maybe scheduling something when there seems to be kind of a well-intended disagreement between the operator and the inspection staff. So that's kind of my 2 cents on the matter. Is I think that there could be some dialogue around situations like this. So I'm just going to kind of throw that out there. I have one more question that I'm going to ask you, and then I'll let you go. is there any merit to Caris's claims that additional human impact on the lands would outweigh the environmental benefit of the corrective actions? And if so, how should we reconcile that?
I do not believe so. I think that performing any reclamation will have more of a long-term benefit for the landscape, as well as public health, safety, environment.
Thank you, Mr. Trio.
Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you very much, Mr. Trujillo. Really appreciate the work that you do and the testimony that you provided. So somewhat similar, and I think you kind of addressed this a little bit with Commissioner Gonzalez's last question. I was, I think you kind of got at it where once you provide the inspection form to the operator, there's somewhat of an expectation that if they have questions or if they have an issue that they will contact you in some form and ask for clarification. And is that correct?
That is correct. Generally, yes.
And so, and if you were to receive a phone call again, if understanding that you are often in the field, do you try to follow up and send an email saying, I received your call, can you email me with, or something to that effect?
Absolutely. That is generally what does occur.
Okay. And then also, it sounds like you also somewhat addressed this, that, if there had been communication back to you, then, and if there was a request that was made for some alternative measure, you could discuss that with your supervisor and manager and work through that. Is that kind of a regular communication that occurs between you and other inspectors and supervisors, managers, et cetera?
Absolutely. I would often defer to the expertise of the field inspection unit, who has more knowledge and, again, experience and expertise within production equipment, workover equipment, et cetera. So we would often have that communication internally with other inspection staff, as well as the field inspection manager.
Okay. And in general, do you feel you have had similar types of communications with Caris in particular at other sites? And is this sort of specific to this site that there have been additional challenges?
No, we have had many conversations with other locations with Caris. We've also had several on-site site visits with both myself, Dr. Arthur, Caris representatives, and Caris is contractors as well. So that has not been an uncommon thing in the past.
Okay. I'm curious also, kind of moving a little bit further into other questions, if you could comment on some of the testimony we heard from Caris about the lack of Form 4s in the area and this perception that it will never be approved. Do you have any comment on that?
No, Form 4s are, I don't think there's been any Form 4 that I have denied. The Form 4, especially in terms of the reclamation section of that Form 4, is a notification to staff that either interim or final reclamation is either in process or has been completed. We will likely make comments on there with the standard language of such. I usually respond saying that approval of this Form 4 is not a passing of the reclamation. However, staff has received notice and will perform a follow-up inspection.
Okay, so you are saying that there have been other Form 4s in this area in the Western Slope that are in the county that have been approved?
Yeah, Form 4s are an extremely common document that we work with.
Okay. All right. Kind of my questions are in a lot of different areas, so I apologize, kind of jumping around a little bit. In some of the photos that we saw from Caris, where they had, post-inspection done some hydroseeding, hydromulching, et cetera, is that sufficient alone to help, with erosion control, or is there a time frame to evaluate the sufficiency? Can you kind of talk a little bit more about that?
I think it would depend in the specific example of hydromulch on many factors, including what kind of bonding matrix they use. I cannot make that assessment on based off solely a photo. But then additionally, there is not only that requirement that operators implement a control measure, but as well as did they maintain that control measure? Have they managed it in a manner that is going to be working as intended to minimize that erosion?
Okay, and relatedly, if they were to kind of come back with for, you know, demonstrating that they had done this hydromulching, would they need to demonstrate other measures, you know, erosion control blankets or something of that nature to show that while, you know, the seeding is being established or the revegetation might be occurring, that they're taking other measures to ensure erosion control? Or can you just again elaborate on other examples of this?
Yeah, so within my role, I cannot be prescriptive and require what specific measures an oil and gas operator would need to implement to achieve compliance with our stormwater requirements. It is the oil and gas operator's responsibility to make that determination and to implement it in accordance with best management practices, and as well maintain in proper functioning condition.
Okay, thank you. And you know, we heard testimony that Caris has their own BMPs document with respect to stormwater management, I think it was. Is that something that you're aware of? Have you seen, have they shared it with you? I don't know. You know, not that there's necessarily a requirement for that to occur. I'm just curious if.
Yes, so in my inspection, it is definitely observed that they have, for example, on the D28, they have a stormwater diversion ditch to intercept, run on to the location and divert it around with use of riprap and culvert in certain areas. The focus of my inspection was that I, at the time of my site visit, observed that within areas of the ditch, that those control measures have not been maintained in a manner that would minimize further erosion or degradation. The soils within that I observed and documented in my inspection report were unconsolidated. You can see vertical incisions occurring within the perimeter or the edge of the ditch and the adjacent upslope areas as well. So based off of my judgment on the observations that I made at the time of my inspection, I did not believe that this control measure was in place and maintained in a manner that would minimize further erosion and degradation within those areas. Again, if we want to specifically discuss the slopes of the D28, these were again areas where I observed areas of erosion where control measures to minimize erosion were not observed, which led to my writing a corrective action.
Okay, thank you. And I was also just curious if you have seen their best management practices document and are aware of what they sort of recommend internally.
Are you referring to their stormwater management plan?
Yes, I'm sorry. It was not erosion specific.
No, I have not seen their swamp specifically or any best management practice document.
Okay, I was just curious. I don't believe we have any requirement, you know, for that to occur, but I just was curious. And you kind of addressed this with your comments just now, but when you're looking at erosion control, are you looking at it from a broader holistic perspective with respect to, you know, as I understand it, probably would not be no erosion ever, but are you prioritizing direct threats to waterways, for example, or, you know, threats to undisturbed areas and, you know, other disturbance caused by erosion to other biological resources, et cetera?
Absolutely, all these are taken into consideration.
Okay, but are you looking at it from the site as a whole or just in specific, you know, kind of isolated areas where you say, okay, right here, the erosion control measures are insufficient, but are you also looking sort of downstream from there in terms of where it may go?
I am. So we do look things on the larger scale of the location as a whole. I know when I had testified earlier and discussed about what we expect with stormwater or site-specific stormwater management, that you need to take in consideration the drainages both above and below the location. Get an idea of what kind of stormwater runoff we can expect on that site, as well as do they have the control measures to manage the runoff as a whole. For example, this specific location, the operator determined that they required a stormwater diversion ditch. But yes, the slopes, the drainage, the soils, all of that is taken into consideration.
Okay, thank you. Just a couple more questions. I think we heard in particular from, let's see here, I think it was Mr. Russell, with respect to some of the photographs and looking at, where you had indicated that there had been, erosion or matters that needed to be, some sedimentation that needed to be better controlled. And I believe Mr. Russell had testified that, there were areas where there was established vegetation kind of just below, what appeared to be a little bit more of a bare slope, and was suggesting, if I understood correctly, that the establishment of that vegetation, in itself helps to maintain further erosion downslope. But I know that some of the photos that we had, that COGCC's had in its exhibits included areas that did not have, vegetation kind of at the base of the slope that might, otherwise help maintain that erosion from moving further. Is that can you comment a little bit on something like that? Would that be, knowing that you can't prescribe a specific solution, but is that something that would address a problem like that, or would you need to see further revegetation on the slope itself?
So I just want to make sure that I understand. You're referring to the fact that the vegetation below these bare areas are in place to stabilize those soils as well as to capture any sediment that might come off of those slopes?
Yes, just kind of in understanding it, in particular, for example, in staff's exhibit D, photo number 7. I don't know if that's something that we could pull up. There's some vegetation that you can see kind of on one part of the slope that we heard in testimony from Mr. Russell that was sort of preventing the downward movement of the erosion. But it does not extend, beyond that. So there's some areas where the slope basically is bare all the way down to the ground area. I'm just sort of trying to understand, what are the types of measures that would address that? And again, is it revegetating the slope itself that is a little bit more vulnerable to continued disturbance just by the nature of the soils, the slope, the scree in the area, or is it, would that vegetation at the base be something that would address that?
Commissioner Nanjapa, if you'd like, I can share my screen with that photo.
That would be great. Yeah, just maybe I can better explain
Sure.
what I'm trying to say.
Yeah. Is this the photo to which you were referring?
Yes, thank you. So, oh, actually, no, I'm sorry. Did I say this?
I think the D28 is what I think you're referring
Yeah,
to.
I think there's a few places where the exhibits, it's exhibit, letter D, but there's multiple 1 through whatever photos.
Okay.
I think it was a different photo number 7 within exhibit D. I'm going to try and see if I can pull that up myself and tell you what the page number is. Apologies. Actually, maybe I may have recorded. Well, we can just look at that particular example if you want to pull that back up.
Sure.
I think there was another one that I was thinking of that was a slightly different example, but this does kind of get at it. So if you look sort of further out along the base where the slope meets the ground, you can see some vegetation along the edge, and there's sort of less bare area just above that. And knowing a little bit about erosion management, that sometimes the establishment of vegetation towards the base of those slopes, or even above, can help to prevent the downward movement of sediments. And so I'm just wanting to understand what are some of the potential solutions in places like this, knowing that you can't be prescriptive, would that be a way to address an issue like this, where you have these soils in, this type of habitat that is a little bit more vulnerable to erosion in general, and in rainwater events, et cetera, in storm events?
So I apologize. I think I'm struggling to kind of track the question itself, but I think I understand. You are asking for me to provide examples of what I may believe are control measures that could potentially address the situation.
Yeah, I'm just trying to better understand, what is, what would have been sufficient, in an area like this. And again, knowing that you can't be prescriptive, I'm just thinking that if there was vegetation all along the base of the slope, that would, I believe, help to control the sedimentation and the movement, of erosion further. And just the root structures, of course, of the plants that would, help to control the erosion. Is that something that would help address an issue like this?
When you're saying vegetation at the base, are you referring to the base of the slope here, or
base of the slope?
Revegetation in itself is considered a best management practice. Reseeding is part of that. However, reseeding alone may not be adequate to achieve stabilization. Revegetation in itself is considered a long-term stabilization, yes. However, it may be necessary for other control measures to be implemented in conjunction with revegetation or reseeding efforts, and maintained until that revegetation has been adequately established. So in terms of reestablishing vegetation, as an example in this photo, at just the base of the slopes would not address the unstabilized slopes themselves. It may intercept sediment coming off of the slopes, but it still does not address the degradation occurring on the slopes. And when you have sediment loss, you have degradation.
Okay, thank you.
I hope I answered that. I know that there was a lot there.
I appreciate it. I think I did a terrible job of trying to explain what I was trying to explain, but I appreciate you kind of talking through that. I was just trying to understand a little bit more about, what would be sufficient. And again, just thinking a little bit about some of the other testimony that we heard about their belief that this was sufficient, why or why not, and what would be, what would be considered, sufficient in some of these instances. And so I think you've at least answered, that for me, that the reasoning behind, or your thought processes behind why something like this is insufficient currently. And so I appreciate that. And I think with that, that's all the questions I have. Thank you.
Thank you.
Commissioner McGowan.
Thank you, Chair. And I have a question to follow up on Commissioner Nanjapa's first question. So I'm going to bring it back a little bit. But in regard to Form 4s, right? So you kind of mentioned that Form 4s are a common document. You see a lot of them. They're commonly approved. But that's because Form 4s are, for multiple purposes. They're just sundry documents, right? They're not necessarily applicable just to interim reclamation. So my question is specifically to Form 4s requesting approval for interim reclamation. Are those Form 4s commonly approved as a regular practice?
Again, yes, we would likely approve those Form 4s if they included the documentation that's required within the 1003 rules, which is the photo documentation as well as the other details. And again, we would likely add the comment here that we have received notice that interim reclamation has been complete, that approval is not passing of the reclamation, and that a inspection will be scheduled.
Yeah, sorry about that. I missed that last part, but that approval is not necessarily approving the interim reclamation. How does interim reclamation get approved?
In terms of, it would be through a field inspection report.
Okay, so a Form 4 submitted saying, hey, I'm done with my interim reclamation. Then there's a subsequent inspection, and then that inspection will have a report saying interim reclamation has been met to our satisfaction.
Correct.
Okay. And how, with what frequency has that occurred in your area?
that I perform interim reclamation inspection in response to a Form 4 sundry.
Yep, and that resulted in approval of that interim reclamation.
More often than not, we would likely put it in the process.
Well, I know you're saying you would likely put it in process, but how many have you put in process?
Well, it's hard to say. Unfortunately, I cannot say that I've come across a lot of locations within the Road Plateau that I would say pass interim reclamation, either because they have not met our standards pursuant to 1003, or they have just not performed the interim reclamation in general.
Okay, thank you.
Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Trujillo, for being here today and testifying. Can you distinguish for me, I'm thinking that revegetation, is that sometimes a best management practice as part of a stormwater management plan, or are those two things considered separately?
So I think it's important to note that the term best management practice is kind of a broad term. Putting up signage saying stay off the reclamation can be considered a best management practice. Having training in stormwater can be considered a best management practice. Control measures are something that are specifically implemented to manage stormwater and erosion. So I think it's important to keep those ideas or aware that there's kind of distinctions between those two.
So sorry, maybe let me be a little more clear. Are revegetation efforts part of stormwater management?
Yes, reseeding and revegetation efforts are encouraged. In fact, a desirable perennial vegetative establishment with good root structure does facilitate long-term stabilization of a disturbance area.
Okay, so I think our rules state that you cannot ask for a variance from stormwater management, but you can ask for a variance, or a landowner could ask for a variance for other parts. I hope that I'm understanding our own rules. So I don't know if you heard the testimony of Mr. Andrews, the ranch manager, where he said that they are choosing to waive any reclaimed efforts on the property. And I'm not sure that that actually is allowable. But if a landowner wants to waive something, is that a Form 4? And have you, if that is yes, have you received that from Karis for this property?
We no longer accept variance requests on a Form 4 as of January 15th again. So all that would go through a commission hearing.
Okay, so all that has to be decided by us. Okay, so sorry. So if a variance request were to happen, I think this question is maybe for our own AAG. Which parts are we allowed to waive per our rules? And I think that you can't ask for a variance from stormwater. So maybe that's a conversation for later, Mr. Chair, but I think I need to understand that nuance. And then Mr. Trujillo, I was just wondering if you have any examples. I think what I'm hearing you saying is you have examples and have in the past worked with an operator who has said, I think that we're misunderstanding you. I see this picture that you took. I don't think you're understanding what the situation really is here. Can you come out and I want to walk you through why I think I have actually met the expectations of rule X or Y or Z, where that conversation has resulted in you changing your mind. Has that happened?
We have met with operators in the past to discuss issues. And in certain situations, it may not completely change the corrective action, but it may adjust certain parts of that corrective action.
Okay, thank you.
Further questions for this witness? The commissioners did an excellent job of rounding out the questions. Mr. Trujillo, just one sort of final matter. You listened into the testimony yesterday of Karis employee Lindsay Ryder, is that right?
I did, yes.
And she testified that in her experience, Form 4s are not something that is routinely used to address sort of this interim reclamation sort of thing. I kind of got the sense that they just, that's just not what happens. Can you provide any perspective as against that line of testimony?
So the Form 4 to provide notification that interim reclamation complete per our rules is required. However, I would say that that is a rule that operators generally have not complied with. I have received several Form 4s from other operators, but largely on a whole, I do not receive a lot of them. Specifically for complete, I have received quite a few of notifications telling me that interim reclamation will commence on an approximate date, but in terms of the Form 4 with the required documentation, including photo documentation, is generally not something I receive on a common occurrence.
Okay. These wells, I believe we have testimony, these wells were drilled in 06 and 07. Does that sound right?
I believe so.
Okay. If the wells were drilled in 06 and 07, and they've been in production ever since, when was interim reclamation supposed to have been done?
I cannot comment whether or not the rules, I don't think the rules for reclamation were different then as they are now, but speaking to what we require in our current rules, interim reclamation would be required on non-crop land within 6 months after drilling and subsequent operations.
Thank you. Commissioners, I believe we are done with this witness at this point in time. It is 12:50. We've got one more witness, and then we've got closings, and then we've got deliberations. Do you want to take a short lunch break? 12:50, maybe return at 1:30, 40 minutes. Does that work for everybody? Commissioner Nanjapa?
Mr. Chair, I think at one point we had a hard stop at 1:30. Do we still today or no?
Oh, help me with that. Do we have a hard stop at 1:30, Ms. Larson?
Moment. Based on commissioner calendars, there was a conflict starting at 2, but if commissioners are able to go past 2 o'clock today, then we certainly can. Mr. Dunn.
That wasn't my conflict on the calendar, but I do have a conflict starting at 4:30. But I can go up to that point as one commissioner. I'll let whoever had the conflict speak up in that regard as to 2 o'clock.
Commissioner
That was my conflict, but I can move it and yes.
I'm gonna make a conflict that we can't go past 4. So
Okay, so we're not going to go past 4. I can make the tuna fish sandwich in 10 minutes. I'm happy to come back at 1. What do you guys want to do?
If people don't mind me eating, I can make my lunch and eat.
All right. It's 12:50. Let's come back at 1:10. It gives everybody 20 minutes to cobble together a quick lunch. All right. It looks like we've got most of us back with us. So it's 1:11 or 1:10. Let's get started back up. Mr. Neslin.
Yes, before we commence, could both parties get a time check?
Ms. Larson, you're muted.
All right, we should be, can you hear me now?
Yes.
14 minutes and 44 seconds for Karis. Staff has 49 minutes and 31 seconds remaining.
Anything else procedurally, gentlemen? All right, seeing none, Mr. Kirshner, you can call your next witness.
Thank you, Chair Robin. I'd like to recall Dr. Arthur.
Hello again, Stephen.
Hi, Dr. Arthur.
Mr. Kirshner.
Thank you. So we're going to shift gears here, and we're going to talk about Karis's request for a surface owner waiver of Rule 1003. and a variance from the requirement to comply with rules 1002F and 1003. We're going to be walking through the requirements to grant each of these remedies. At the outset, to frame all of this, I want to remind the Commission that pursuant to the 2020 Statement of Basis and Purpose to the Mission Change Rulemaking, the Commission's 1000 Series Reclamation Rules, specifically 1003, are explicitly intended to protect biological resources and to restore vegetative communities. Now, this is a starting point for reclamation staff when it reviews these variants and waiver requests. So it's important to keep in mind as we review Charis's request today. So with that, Dr. Arthur, you described your role with the Commission earlier this morning. Does that role include regularly evaluating surface owner waiver requests?
Yes, it did.
Okay. I'm going to share my screen. Can you see this document, Dr. Arthur?
I can.
Okay. And this is actually going to go to Commissioner McGowan's question as well. Rule 1000C requires that an operator demonstrate to the directors of the Commission's satisfaction that compliance with the rules is not necessary to protect the public health, safety, and welfare, including prevention of significant adverse environmental impacts. Now, directly to Commissioner McGowan's question, the rule specifies that, I can't highlight, no, maybe I can highlight this. Okay. The rule specifies that surface owners cannot waive compliance with Rule 1002F. So this surface owner waiver would apply only to Rule 1003, which is the interim reclamation rule. So when we talk about just the surface owner waiver piece of this, we're only talking about Rule 1003. So Dr. Arthur, you've heard Charis's presentation, you've heard staff's presentation. Have you had an opportunity to review Charis's application, Charis pre-hearing statement and its exhibits?
Yes, I have.
Okay. And in order to protect the public health, safety, and welfare, including prevention of significant adverse environmental impacts, in your professional capacity, do you believe that compliance with Rule 1003 at these sites is necessary?
Yes, I do.
Can you tell us why?
So we need to have an evaluation of the location to make sure that it's protective of public health, safety, welfare, and the environment.
Do you believe that's occurred in this case?
I do not.
Okay. Once again, as I stated in my opening this morning, I want to remind the Commission that it is Charis's burden to show that they comply with Rule 1001C. Dr. Arthur, given your expertise, your experience in evaluating these surface owner waivers, do you believe Charis has met that burden?
No, I don't. I do not. And a full evaluation hasn't been made. At a minimum, they haven't addressed the potential impacts to wildlife, including small mammals, reptiles, insects, both aquatic and pollinator invertebrates. The locations from where they seek a waiver are designated high priority habitats for cutthroat crucial habitat, aquatic native species conservation water, as well as winter concentration areas for both elk and deer. Additionally, they have not addressed the impacts that the lack of interim reclamation has on long-term stabilization of the location.
So given this, Dr. Arthur, do you believe that the Commission should grant a surface owner waiver from compliance with Rule 1003?
I do not.
Okay. I'm going to shift now to talk about the variance. And just to be clear, the variance would apply to Rules 1002F and Rule 1003. Dr. Arthur, does your role at the Commission include evaluating variance applications?
Yes, it does.
And approximately how many variance applications would you estimate that you've reviewed in your time with the Commission?
Approximately 500.
Is there a standard procedure that you use to walk through these variance applications?
Yes, we have a procedure. The reclamation staff for that particular area goes through the variance request first. We have internal checklists that we go through and we look for specific components within that variance request package. So for instance, we would look for a signed waiver from the surface owner. We might look at whether the variance was submitted soon after corrective action inspection. We consider if the request has, the variance has a specific intended use. So the reclamation specialists then go through the documents. They put together a summary. I go over that summary with them. And that would again be the regional reclamation inspectors. And then a staff recommendation is decided upon, and then staff brings that recommendation to the director of the commission.
And that was prior, that was when these variance applications were submitted on Form 4s, right?
That's correct.
Okay. You said you made recommendations to the director based on your expertise and your experience. Has the director ever overruled your recommendation on a variance?
No, they have not.
Okay. I want to turn now to the specifics of Caris's variance application. Now, as we said in our opening, as we're showing here on screen, Rule 502C requires that the operator, in this case Caris, make a showing that they meet the listed 5 elements for determining whether the commission should grant a variance. In other words, it's Caris's burdens to establish all of these 5 elements that are listed here. Now, the first is whether Caris has made a good faith effort to comply with these rules, namely 1002F and 1003. Based on your review of the inspection reports, the materials submitted by Caris, the testimony you've heard from both parties, and the details of the specific locations, do you feel that Caris has made a good faith effort to comply with these rules?
No, I don't. A good faith effort really implies in the beginning that an effort had been made. In some of these rule violations, there is a complete absence of an attempt to comply with the rule. Or if they did have an attempt, it was inadequate. So for instance, pertaining to 1003 interim reclamation rules, from a review of the historical aerial imagery and on the ground inspections concerning the reclamation of areas no longer needed for production, there was no attempt to conduct interim reclamation, or the reclamation in some cases were inadequate and not progressing toward meeting the rules after an extended period of time. So either way, in my opinion, there was not a good faith effort. For interim reclamation, there are still large areas not needed for production. And to my knowledge, the operator has not tried to comply. Regarding stormwater, staff has stormwater concerns about bare slopes, where there was evidence of site degradation and erosion. Just doing something doesn't constitute a good faith effort. It requires a legitimate evaluation of best management practices for stormwater. It requires BMPs to be planned, installed, and maintained per good engineering practices, and possibly changing those practices if they're not working. Caris could have worked to address the corrective actions and then communicated to staff through required channels, the FIRR process, or potentially submitting through a Form 4 stating that the interim reclamation was complete or ready for inspection, or that the stormwater corrective actions had been addressed.
Thank you. So the next element here is Caris is alleging that granting this variance would in fact, well, the next element is that the requested variance would not violate the basic intent of the act. Now, Caris alleges that granting this variance would in fact promote the intent of the act, because as they've argued, further interim reclamation operations would generate environmental impacts without commensurate benefits to them, the surface owner. Do you agree with that?
I do not.
And Caris is essentially saying that, complying with stormwater rules and properly conducting interim reclamation would require it, for instance, to import topsoil and fill. It would involve fuel emissions, water consumption, dust mitigation. Are these considerations unique to Caris?
Oh, no. These activities are routine and definitely not unique to Caris or these locations. There are many environmental costs to construction and production of all oil and gas. And yes, there may be some short-term environmental costs to conducting reclamation. However, the short-term costs do not outweigh the long-term benefits of reclamation. Reclamation is one of the primary protections of public health, safety, welfare, and the environment, and wildlife and biological resources.
Do you feel that it would be detrimental for the commission to agree here that these short-term routine impacts are sufficient to grant a variance?
Yes, I think it would be detrimental. I'm not sure how many other operators would then seek variances based on the short-term environmental cost of conducting the reclamation. And we wouldn't be taking into consideration the long-term benefits and the protections to the environment, wildlife, biological resources that reclamation actually would provide.
Thank you. The next requirement of the rule here is that the requested variance is necessary to avoid an undue hardship. Now, Caris argues in its pleadings and today that requiring it to comply with stormwater rules and to conduct interim reclamation is in fact an undue hardship. It argues that it's an undue hardship because it would require the expenditure of substantial resources. I want to note for the record here that the Colorado Supreme Court has previously stated in Wood Brothers Homes versus City of Colorado Springs that when considering the meaning of undue hardship, financial detriment is not alone enough to establish undue hardship. And the commission's recognized this previously in its consideration of the Grand Mesa variance as well. I think that was back in December. Caris then goes on to argue that it would repeat reclamation that was previously completed by its oil and gas predecessors. Just to clarify there, since oil and gas operations disturbed these locations starting in 2006, has reclamation ever been previously and satisfactorily completed?
No, it has not. There are still areas not needed for production that have not been reclaimed, or other areas of interim that's not progressing towards meeting the rules. Additionally, all operators actually need to expend substantial resources for operating and maintaining oil and gas activities. And considering that Caris has owned these operations since 2017, they should have planned for that expenditure and resources like all other operators are required to do.
Thank you. As we discussed earlier, prior to the oil and gas disturbance at the location, the state of Colorado recognized that this area had been fully reclaimed, and the state released the mining operators reclamation bond in full. As you testified earlier, aerial photos taken in 2005 prior to disturbance show a consistent cover of vegetation. Have you seen any evidence that since that time, the portions of these locations unneeded for production were reclaimed to commission standards?
No, I have not.
Then I'll ask you, is it true that reclamation was previously completed here?
No, it was not.
And do you believe that it would be an undue hardship for Caris to comply with stormwater rules and to conduct interim reclamation?
No, I do not. I believe that it's the burden of all operators to abide by other rules and to address impacts caused by their voluntary operations.
Thank you.
Whether that be building it or buying operations.
The rule next requires that Caris make a showing that granting this variance would result in no net adverse impacts to public health, safety, welfare, the environment, or wildlife resources. Now, Caris is alleging that it would not result in a net adverse impact. So I'll ask you, in your professional opinion, do you believe that allowing the sites to persist in their current condition could cause adverse impacts?
Yes, I do.
Can you tell us why?
This requires the operator to make a showing that granting this variance would not result in adverse impacts. We have seen no information from Caris that really addresses whether the lack of reclamation or stormwater would not cause adverse impacts. It is the burden of proof for them to provide a full evaluation and why there would be no adverse impacts. By just saying that there are no impacts would not be enough for the commission to evaluate the variance. Regardless, I believe that the impacts would exist to these high priority habitats where these locations lie. Not reclaiming or conducting stormwater controls would equate to loss of habitat and would leave these lands and water vulnerable to adverse impacts that could affect wildlife and other biological resources.
Thank you. So finally, Caris is required to show that the variance contains reasonable conditions of approval or other mitigation measures to avoid, minimize, or mitigate adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Dr. Arthur, have you reviewed Caris's application for a variance, its pre-hearing statement, and all of its exhibits?
Yes, I have.
And in any of those materials, have you seen any conditions of approval or other mitigation measures that would ensure that adverse impacts would be avoided, minimized, or mitigated?
No, I have not.
And commissioners, here I'd like to show, see if I can find it. One moment, I'm going to have to open up another document here. Excuse the delay, I'm going to share my screen one more time. Commissioners, I want to know, I'm showing you Karis's pre-hearing statement. You heard Dr. Arthur's testimony just now that her review of Karis's application revealed no conditions of approval, no mitigation measures to address impacts. And in fact, Karis agrees. Karis says here that it believes its track record of successful reclamation and environmental stewardship obviates the need for additional conditions of approval. Karis has declined to provide any conditions of approval or any mitigation measures to address potential impacts at this site caused by their attempts to avoid compliance with these rules. Now, Dr. Arthur, Rule 502C overall requires that Karis make a showing that it meets all of the 5 elements we discussed here. It is Karis's burden to prove these. Given your expertise in general, and specifically in reviewing variance applications, do you feel that Karis has made a showing sufficient for the commission to grant this application for a variance?
No, I do not.
And in your expert opinion, should the commission grant Karis a variance from rules 1002F and 1003 at these locations?
No, I would not recommend approval of these variances.
Thank you, Dr. Arthur. I have no further questions at this time.
Mr. Neslin?
Thank you, Chair Robbins. Again, I'll try to be brief. Dr. Arthur, a pleasure to see you again this afternoon now. I'm going to follow up where I left off this morning. At the end of your prior testimony, you had testified that you reviewed Karis's application for declaration of compliance, or in the alternative for approval of variance, right?
Yes, lots of documents.
I want to show you the last page 14 of that application and some highlighted language. And again, I'm going to have to rely on my colleague, Mr. Coles. There we go. And I just want to refer you to some of the highlighted language there where it says Karis recognizes and appreciates the commission's ongoing duties to ensure proper reclamation and promote environmental responsibility, and dropping down that Karis would happily accept reasonable conditions of approval for a variance. Did you suggest any conditions to Karis for this purpose?
No, I did not.
And I understand, as I think you testified for Mr. Kirshner, that there's not a requirement that you do so, but just in the interest of being helpful, did you suggest anything to Karis here?
No, I did not.
How many times have you visited the 2 well sites in question?
Once.
And when did that occur?
July 2021.
And how long did you spend there?
Good question. Probably about an hour and a half.
And you talked about, for Mr. Kirshner, you expressed a number of concerns about public health, safety, welfare, and protection of the environment, or avoiding significant environmental impacts. When you visited the site, did you see any members of the public?
No, I did not.
I mean, you heard testimony from several Karis witnesses that the ranch that contains the 2 sites is not open to the public, is private, and that there is not public access. Do you have any reason to disagree with that?
No.
And do you have any data demonstrating that the 2 sites are discharging pollutants to the East Fork Creek, the East Fork of Parachute Creek.
No, I think that would be Karis's burden
Do
to
you
show us
have,
that there would be no impacts.
do you have any data demonstrating that the two sites are contributing to a violation of state water quality standards?
No, and it's not required.
Do you have any data demonstrating that the sites are contributing to a violation of Air Quality Control Commission requirements?
No, I do not.
Do you have any data demonstrating that the current condition of the sites has caused any wildlife mortality?
No, I do not, but that is the burden of Karis to tell us that it's not going to cause any adverse impacts to not conduct these operations per the rules.
Do you have any data indicating that the current condition of the sites has caused wildlife to alter migration patterns?
No, I do not.
And do you have any data indicating that the current condition of the sites has reduced wildlife populations in this area?
No, I do not.
You testified about a number of requirements for a variance. And I just want to clarify a couple of these. Karis is the surface owner here, correct?
Correct.
And so by submitting the application, Karis was waiving, was waiving the additional reclamation requirements, correct?
I don't understand the question. So
I'll rephrase it. My fault. Karis is not seeking a waiver from all interim reclamation requirements, is it?
yes, it sounds like they are on both locations.
Well, let me respond or clarify this. I mean, doesn't the application simply seek a waiver from the additional corrective action reclamation requirements issued by Mr. Trujillo?
I think that might be a lawyer question.
All right. A prior reclamation did occur at the sites, did it not?
I do not believe that all areas need for production. They did stabilize some of the area around the oil and gas locations. On one of the locations, they did conduct interim reclamation, but that is not progressing toward meeting the standards.
Mr. Goals, could you bring up the photograph? The photograph of, well, I'll represent, this is, Michael, this is D28, correct?
Yes, Dave, that's correct.
Okay. Dr. Arthur, can you see this photograph is an aerial photograph of the D28 site from 2017?
Yep.
You see that?
Mhm.
Can we go to the next picture?
Yeah.
And which exhibit is that, Michael?
That's staff's exhibit G at page 80.
Very good. And could we go to the next photograph that we want to reference? And this is a Karis exhibit. Which exhibit is it, Michael?
This is Karis's exhibit 1. That's page 8 of the record, found at page 11 of the first volume.
And Ms. Arthur, you can see that the area has shrunk quite a bit. This is an aerial photograph from 2021. So 4 years after Karis acquired the site.
Right. So on our inspections, we're not disputing that reclamation occurred on this particular location. The inspection states that it's not progressing toward meeting the rules.
I'm just pointing out that Karis, some significant interim reclamation has occurred over the years. We believe beginning in 2012 and
For the
continuing.
D28?
Yes, for both sites and continuing in different ways over the years. So
I would disagree for both sites.
okay. which site do you disagree as to?
The H29.
And the use by Caris of these sites is specific, correct? Caris is,
As an oil and gas location, yes, it is.
and also for purposes of the wildlife management plan with CPW and Caris's own holistic grazing plan.
Well, we weren't given the holistic grazing plan, actually, so I'm not really sure how that all fits together because it wasn't part of your package. We did receive the wildlife plan that was expired, so I'm assuming you have another one that isn't expired. And when I looked at that wildlife plan, it didn't really address not doing interim reclamation. The sections that talked about the interim reclamation and final reclamation portion was in the integrated vegetation management guidance section, which was not provided.
And Ms. Arthur or Dr. Arthur, you saw the testimony of Mr. Russell. There are a variety of BMPs on these sites, correct? Stormwater BMPs.
In terms of what, so are we talking about stormwater or are we talking about wildlife?
We're talking about stormwater BMPs. Both
Yeah, so
sites
they're-
contain a variety of stormwater BMPs.
Yeah, so we have some areas have better BMPs than others, yes.
Ditches, culverts, compaction, vegetation. We may disagree about the sufficiency, but there are those forms of BMPs on both sites.
Yes.
Okay. I have no further questions.
Thank you.
Kirshner, do you have any redirect?
I do not, Chair Robbins. Thank you.
All right, commissioners, do you have questions of this witness? Commissioner Nanjapa?
Thank you, Mr. Chair. Just a quick one, and thank you, Dr. Arthur. Appreciate your testimony today and the work that you're doing. I was just curious, just again, thinking through the communication. So as Mr. Trujillo had mentioned, you know, the inspection form itself is a form of communication. There's a little bit of an expectation that the operator, if they have questions or concerns, that they will communicate back. Is there a point at which you might get involved as the supervisor if there's a challenge or a disagreement between the operator and the inspector?
Absolutely.
Can you just elaborate on sort of how that might occur or perhaps in this instance, how it occurred?
So I have ongoing conversations with all my inspectors. If there are challenging inspections, that was one of the reasons I visited the site with my inspector. I do on-sites with my inspectors in various capacities across the state. Communications would go from the, you know, if I got a phone call, I would probably roll in my area reclamation inspector. I'd review the inspection because my inspectors do very detailed and well put together inspections, and they're well documented. So we would go through all those things together.
Okay, thank you. And prior to the letter that came to Director Murphy, did you receive a call from Caris at all about questions or concerns about the inspections? And
I did not.
Corrective actions?
No, I did not.
And when Director Murphy received the letter, did she give you any direction or guidance on contacting Caris?
Well, at that point, it was, you know, a letter addressed to her, and it was most of that work was done with the manager, Mike Leonard, and Julie Murphy. And I wouldn't automatically respond to something that was addressed to her unless she had asked me to.
Okay, and so that was the point at which Mr. Leonard then reached out and spoke to, it sounds like there was some communication, or if I remember correctly, emails maybe between Mr. Leonard and members of CARES. Is that correct?
I'm not sure the order of the
Okay.
timeline on that.
Okay. Okay, thank you.
Dr. Arthur, can you elaborate further on these commission staff's response to the letter? What happened? If you know.
That stayed above my pay grade.
Okay. Mr. Kirschner, can you answer that question?
I can say only that CARES elected in this instance to respond to a staff inspection by appealing directly to Director Murphy. I am not aware of how Director Murphy responded to that letter, but I would say again that CARES knows what the proper channels are to describe work done in relation to an inspection report. CARES knows how that procedure is supposed to work. CARES is a very sophisticated operator. Mr. Nelson is sophisticated counsel. Instead, they went directly to the director. And I don't know what the nature of the director's correspondence, if any, was with CARES after that letter.
All right. Well, I'd like someone to address that question in closing when we get to it. Dr. Arthur, you were asked on that cross that, or noted that you were told that in the letter or in the application that CARES said that they would accept COAs for a variance from the COGCC, and that you did not submit any COAs. Why is that the case, if you know? Like, why did you not respond? Is it, again, because it was addressed to Director Murphy?
Well, I think we needed to get to this point in terms of the variance being looked at, and it didn't meet all the components of the variance.
Okay.
It didn't meet the burden.
Okay, fair enough. Thanks. Other questions of this witness, Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Dr. Arthur. Some valuable insights. I guess I'm trying to figure out if interim reclamation is supposed to be done 6 months after completion of the I'm not sure what the wording I want to use, when the site starts operating, and they drilled in many years ago, and now we have a reclamation specialist coming out to inspect. I'm wondering, can you just explain to me like the timing and why it's happening now? And I'm trying to put myself kind of a little bit in the shoes of the operator, which is, you know, we've been operating for a while and we've had these best management practices in place. And now the interim reclamation specialist is coming in and maybe feeling a little flat-footed because of the timing, or maybe not, but if you could just kind of explain to me how this works and why this feels kind of late to me.
So the timing is that there are areas where operators are not complying with interim reclamation. And I have limited staff. And so when we come upon these locations that don't have proper interim reclamation, we asked for it to be conducted. Because they haven't conducted in the past doesn't necessarily mean they don't have to abide by the rules. So therefore, that's why we submit a corrective action inspection and then wait for the operator to then comply with the rules and the intent of the act.
So would you expect to see if interim reclamation was supposed to have taken, I would argue, years ago, would you expect to see more vegetation having occurred on those reclamation sites than what your inspector saw?
Yes, and that's part of the analysis that we were looking at, is like, are these areas progressing? The area that they had, they moved some soil in, they vegetated it, is it progressing toward the standard? Is it becoming established? So that was one of the things that we looked at. And again, why is it taking so much time? So maybe it's not adequate what they have, whether they need to do something different. We're not going to be prescriptive in that, but in order to meet the standard, then they need to do something else potentially, or something in addition to.
Thank you.
Sorry, I was typing. Commissioner Messmer.
Thank you, Mr. Chair. Thank you, Dr. Arthur, for your dual testimony here. I've got just a couple of questions. I wonder if we could chat a little bit about performance versus prescriptive, and understanding that some of the standards we have in our rules are performance-based standards, and there are some prescriptive measures in there in order to be able to ultimately meet the performance-based standards. But there are performance-based standards, and so how do you and your reclamation staff, approach those performance-based standards as far as communicating with operators ultimately what the expectation is for them to comply with the rules?
Are you referring to the 80% vegetation cover, or what?
I mean, we could go there. I mean, that'd be a good example, a more specific example, I guess. But I mean, how do you, share, how do you create the bar so that an operator clearly understands, what they need to do in order to meet the standard, right? And understand it's a site-specific situation. There's lots of different ways to approach it. One particular approach isn't always the best approach, and so I mean that's what a performance-based standard is. So, but how does that communication happen between Cogcc and an operator as far as understanding what the bar is, or at least that dialogue? Understanding there's probably a little dialogue associated with that.
So I feel like the bar is per good engineering practices. So what we would like the operator to do is to make sure that they're implementing, planning, and conducting these BMPs per good engineering practices. So that's the bar we look at. We don't tell them exactly what to do because we aren't prescriptive, but we do have that bar that it needs to go in per good engineering practices.
And for the vegetative standard,
Yes.
I mean, that one's, at least to me, relatively clear in the rules that it has to be, 80% of whatever the native cover is. And, I know that some adjacent vegetation may not be always accurate, but I'm assuming that a reference area doesn't include cherry picking something that is the worst vegetative cover in a particular area, right?
That's correct. We try to pick the most representative reference areas to these locations that have been disturbed.
Okay. Thank you. I appreciate that.
Further questions? All right, I'm not seeing further questions. Thank you, Dr. Arthur, for being with us and for your testimony today.
Thank you.
All right, anything further, Mr. Kirshner?
Nothing further from staff.
Are we ready to move to closing argument?
Chair Robbins, I believe the parties had reserved time for rebuttal at the end of the witness testimony. I was hoping we might get a time check and move into rebuttal.
Yes, Karis has 6 minutes and 9 seconds remaining, and staff has 32 minutes and 36 seconds remaining.
Chair Robbins, clearly we'd have to keep rebuttal extremely brief, but we'd like to bring on rebuttal witnesses if that's okay with the commission.
Yeah, that's fine. Sorry, I still don't think I've got the final pre-hearing statement and case management. So
that's pretty understandable in this case. Karis would like to call Miss Lindsay Ryder as a rebuttal witness.
All right, we will find her and make her a panelist.
Another note, we would like to call Holly Hill as a rebuttal witness as well, and she hasn't been sworn in as a witness.
Why don't we go ahead and get her on board now, and we'll swear her in, and then you can move into rebuttal.
Okay. Mr. Chair, may I go ahead? Thank you. Ms. Hill, I'm Kyle Davenport. I'm going to swear you in. I'm counsel to the commission. All I'm going to ask you to do is to raise your hand and state your name and say that you swear to tell the truth. So whenever you're ready, please go ahead.
My name is Holly Hill, and I swear to tell the truth.
Thank you.
Mr. Goltz, I believe the floor is yours for 6 minutes and change.
Thank you, Chair Robbins. Karis would like to call Lindsay Ryder as a rebuttal witness. Good afternoon, Ms. Ryder. I'd like to keep this brief. Obviously, we're getting short on time and it's been another long day. I think you understand from the commissioner's questions that there's a concern about how this matter has landed at hearing and the channels that it's gone through. You heard earlier that Mr. Trujillo testified he generally maintains communications with Karis, and I'm curious if you agree with that statement.
No, typically he does not.
And how would you generally characterize your communications with Mr. Trujillo when he issues corrective actions to Karis's sites?
If we have a question, typically we have been able to call him, or we would call him and request, a short conversation to clarify the citation. He typically does respond with an email, and he typically just reiterates the corrective action and provides little guidance. In one example that I was able to find regarding the H29A, it also was in regards to another location we were working on about reclamation and remediation. I had called, left a voicemail. He responded with an email. I requested a 30-minute conversation just to quickly clarify my questions, and I never heard from him again.
And Ms. Ryder, to clarify, when did you last email Mr. Trujillo? You mentioned that email was regarding one of the sites at issue, either of the sites at issue in this hearing?
Yeah, it was regarding the H29A. We had some questions around active remediation in regards to reclamation, and that email was sent March 18th, 2021.
Okay. And to confirm, you never received a response from Mr. Trujillo?
That's correct.
So is it your testimony that you did in fact reach out to the inspector in this matter requesting additional conversation and guidance regarding this matter, and that you only issued a letter to the director after that process and not receiving a response?
That is correct.
Okay. I have no further questions for Ms. Ryder.
Mr. Kirshner, any cross?
Nothing at this time. I would obviously say that staff hasn't seen any of these emails. We're completely unaware of them, and they haven't been admitted into evidence. But I have no further questions.
And I would represent that we do have those emails that they were sent on March 18th, and that we are happy to offer them if the commissioners are interested in seeing them. That's all.
I don't know that that's at least from this commissioner's perspective, I don't know that that's necessary. I'll take Ms. Ryder at her word.
Commissioner Robbins, excuse me, can I ask one more question of the witness?
Oh, sure.
Thank you, Ms. Ryder. I just want to ask, did you have a call with staff on March 22nd?
I may have, yes.
Okay. You had a call on March 22nd. Did that relate to location number 335594, what we've been referring to as the H29A?
I can't recall if that was the exact location, but we were also calling about the G29 location. Maybe that's what you're referring to.
Sure, I'm going to share my screen. What I'm showing you is Denise Arthur's calendar for March 22nd, 2021. This is labeled as calls with Lindsay Ryder, Karis, locations 335-573 and 335-594, the H29A. So given this, is it accurate that you say you never had any response related to the H29?
Not from Aaron, no.
But you spoke with staff, didn't you?
I did speak with Denise, yes.
I have nothing further.
Well, tell us about that conversation, Ms. Ryder.
Gosh, I took notes, but I don't recall all of those details right now, especially just given it was on a different location. But we've had some challenging conversations about what is required when we have an active remediation going on. And we were told we needed to submit a variance for interim reclamation on a couple of these locations with active remediation, and we disagreed. And when we disagree with the corrective action or the suggestion of staff, we were told to take this to the hearing. And again, this is why we're here.
Okay. Do you have any factual information as to, after you sent the letter, what staff did, if anything? I tried to ask this question earlier and no one seemed to know the answer.
After we submitted the letter, my understanding is we had our council speak with Cogcc management, Mike Leonard, Julie Murphy, and I believe staff was told that we were going to try to resolve the issues and work together on them. I'm not quite sure what those conversations were. I would defer to Mr. Neslin on that.
Okay, thank you. Any further questions of Ms. Ryder from commissioners? There's a question from Commissioner Messner.
Thank you, Mr. Chair. And thank you, Ms. Ryder. I'm going to try to formulate this question because I'm interested in how these communications occur, and from your perspective, kind of what you think your responsibility is versus what you think staff's responsibility is, and interim reclamation conversations. And there is a challenge between basically asking staff to do the prescriptive interim reclamation BMPs for you versus you understanding what the expectations are and coming up with a performance-based BMP plan that you would implement yourself, right? And so, like, what ideally would you like to see from staff as far as communications, as far as understanding kind of what those performance-based expectations are, understanding that Karis ultimately would have the burden to implement something that worked, right?
Yeah, I agree with you. The reclamation standards are quite clear. 80% is easy to measure. We can have those transects done. So I think those standards are quite clear. I think with the stormwater prescription and standards, that's where there is some subjectivity, and the performance standards come into play. My experience, though, has been that, when we get these corrective actions and we request, like, hey, can we look at this one specific BMP, we don't understand, for example, like erosion, what constitutes erosion? is it our word against theirs? Is erosion meaning that there's a mountain coming down on the location or just a few grains of sand? I sometimes get the feeling that staff wants zero erosion and zero degradation, and those are standards that can't be achieved. So I think that, I think we have to work together on what performance really is and really look at these locations and all the best management practices that are employed to determine if we are in compliance with the intent of the rule.
Okay, thank you.
Further questions, looking around, going once, going twice. Mr. Goltz, I believe we now have an opportunity for the remaining portion of your time with Ms. Hill for rebuttal.
I believe Mr. Neslin was planning to ask some questions of Ms. Hill.
Chair Robbins, excuse me, before council gets started, can I just get a time check?
Yep.
One moment. Staff has 31 minutes and 29 seconds. Karis has 3 minutes and 49 seconds.
Thank you.
Ms. Hill, what is your occupation at Caris?
I'm the regulatory manager.
And were you involved in the decision by Caris to file its application in this case?
I was.
And why did Caris file the application and
Caris
choose
filed-
this course?
Caris filed the application because we did not think that a FER was an appropriate action, because a FER implicates that you have completed a corrective action. We had questions on a surface owner variance possibility and a surface owner waiver. So we were trying to work with staff on what that meant. So we submitted a letter to the director. We copied Mike Leonard, Denise Arthur, and Aaron Trujillo, and we did not get a response from any of those individuals. So we decided to engage you as our counsel to reach out to COGCC staff, namely Mike Leonard, and see if we could engage in any discussions from there.
And what was the response you received?
Mr. Leonard relayed to you that if we did not agree or we were dissatisfied with the corrective actions, that we should seek a hearing.
I have no further questions.
Any cross, Mr. Kirshner?
I have no cross, Chair Robbins. Thank you.
Any questions from commissioners? Commissioner McGowan and then Commissioner Najapa.
Thank you, Mr. Chair. Thank you, Ms. Hill. Is it possible that the response from Mike Leonard to go to the commission is because variances can only go to the commission? So that's a remedy that he or his staff could not have afforded you?
So our request initially in the letter was to close out those inspections. And if not closing out those inspections, to give us a 90-day extension to meet those corrective actions. So that was initially our first ask, and we did not get a response on that. And then the next course of business was Mr. Neslin talking to Mr. Leonard that we disagreed with these corrective actions. And then the next course of business would be to seek a hearing.
Thank you.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you, Ms. Hill. Could you describe a little bit the nature of that conversation with Mr. Leonard? Was there discussion about the inspections themselves and closing them out, or what was required or what was at issue?
I would probably have to defer to Mr. Neslin on this. He relayed back to us the conversation that he had with Mr. Leonard. I believe it was very brief, though.
Let's just ask him. He's in the room. Mr. Neslin.
Yes, happy to answer that question if I may. And I sent Mr. Leonard a follow-up email summarizing the conversation, which is Exhibit 24, Caris's Exhibit 24. And I called Mr. Leonard to remind him that Caris had submitted a letter regarding the inspections, identified the sites in question, referenced the date of the letter, explained that Karis wished to close out the inspections. I recall also saying that Karis would like to meet and work through any issues. And Mr. Leonard advised me that if Karis was dissatisfied with the corrective actions, then Karis should go ahead and seek a hearing on this subject before the commissioners. And I subsequently informed Mr. Leonard by email that Karis would apply for a hearing, but that would require some time to get it scheduled and heard. And so we asked that the correction action dates be extended and that the COGCC take no further action regarding the inspections until the hearing was convened.
Thank you for that answer, Mr. Neslin. And since you're a lawyer, you got to tell the truth. So you're under oath.
I'm an officer of the court.
Yes, you are. All right. Any further questions of anyone in the room? Mr. Kirshner?
I'm sorry, I'm having some internet difficulties. Can you tell me the last thing you said?
The last thing I said?
Yes, I didn't get it.
I just asked if anybody had any other questions.
Oh,
I
not
was
at this
mostly
time.
looking at the commissioners, but if you have a question, let me hear it.
No, sorry, I'm just having some, I guess, some internet interruptions right now, but I don't have any questions at this time.
Okay. Mr. Goltz, does that then halt or finalize your rebuttal?
I believe so, but I'll refer to Mr. Neslin.
Yes, Commissioner, that completes our, Chair Robbins, that completes our rebuttal.
Very good. Okay, are we at the point in the game in which we will hear closing statements? I look to Mr. Neslin and Mr. Kirshner because I still don't have the final order in front of me. So can you tell me what's next?
Yes, Chair Robbins, I believe that we are ready for closing.
And how much time do each of you have for closing statements?
I'll obviously, if I'm incorrect, I'll allow Mr. Neslin to correct me, but I believe we were granted 5 minutes for closing.
Does that sound about right, Mr. Neslin?
Correct.
Okay. Are you both ready to go now? Do you want 5 minutes to gather your thoughts?
Staff's prepared.
We're prepared, Chair Robbins.
Well, then let's roll. Mr. Neslin.
Chair Robbins, Karis did not bring this action precipitously or antagonistically. Karis sent a letter to Director Murphy, Compliance Manager Leonard, Ms. Arthur, Mr. Trujillo, requesting closure of the inspections and raising a number of the issues and concerns that you've heard testimony about. Karis didn't receive a response. The next month, I followed up with Mr. Leonard regarding the letter. He told me that if Karis was dissatisfied with the inspection results, then Karis should seek a hearing before the commissioners. About a month later, Karis filed its application to gain clarity regarding policy issues that impact numerous locations which Karis acquired from previous operators. No one at the COGCC ever suggested that Karis file a FER or offered to meet or discuss these issues. Karis is a good operator and steward of the environment, and it has done significant work in these areas over its recent period of ownership. It acquired the sites following interim reclamation, and it reasonably relied on prior inspections to determine interim reclamation and stormwater management did not violate the commission's rules. Prior inspections are an important lodestar for Karis, which performs due diligence to know what its obligations are when it acquires producing wells. The compliance of the sites remains evident today, and Karis respectfully submits that it has complied with rules 1002 and 1003. Interim reclamation has been completed through methods including revegetation and compaction, and the success must be judged in light of the naturally erosive environment and conspicuous and widespread mining history. With respect to the H29A, interim reclamation is further limited by the ongoing remediation project and the areas required for future well maintenance described by Mr. Middleton. If the commission were to deny Caris's request for declaratory relief, then the commission should nonetheless defer to Caris's use of its land as the surface owner, including its holistic grazing operations, which promote wildlife habitat as discussed by Mr. Adams. There is no persuasive evidence that revegetating the very small areas at issue is necessary to protect the public or prevent significant adverse environmental impacts. The areas at issue are not open to the public, are not causing sedimentation. There is no evidence that they are adversely impacting the environment, and they are distant from the East Fork of Parachute Creek. With regard to stormwater, site-specific BMPs have been implemented and maintained in good faith. Operators need not, cannot prevent all erosion or instability, and Rule 1002F doesn't require them to do so. Mr. Russell and Mr. Trujillo both agreed that erosion cannot be entirely eliminated and that is not required by rule. Mr. Russell and Mr. Trujillo also agreed that the area contains areas that are naturally bare, that the hillsides contain areas that are naturally bare or have sparse vegetation, similar to some portions of the sites in question. It's a challenging landscape. Alternatively, Caris has shown it is entitled to a variance. Further interim reclamation is not necessary to prevent significant environmental impacts. And in fact, further operations at this time would have significant environmental impacts on their own. These impacts aren't warranted. Again, these are extremely small areas that have been produced in their current form for going on 14 or 15 years. In conclusion, Caris respectfully requests that the commission declare it has complied with rules 1002 and 1003 and close the inspections at issue or recognize a surface owner waiver as to the additional reclamation, interim reclamation that Mr. Trujillo has required. Alternatively, Caris requests that the commission grant Caris a variance from these requirements at this time, again, only with respect to the corrective actions at issue. Thank you.
Thank you.
Thank you.
Mr. Kirschner, I believe you are now up.
Thank you, Chair Robbins. Can you see my screen?
Yes.
Great. Again, I want to thank you, commissioners, for your attention and for your questions throughout this process. They've been really appreciated. I want to briefly sum up staff's presentation and the relief that we're requesting today. Caris is asking for what it refers to as a declaration that it is in compliance with rules 1002F and 1003. Earlier, you heard testimony from Dr. Arthur about the history of the site. Prior to the oil and gas disturbance, the site had passed reclamation by the state, with the state returning the mine operator's bond in full and remarking that the site was covered in, quote, an excellent cover of vegetation. You saw aerial photos showing a consistent cover of vegetation across the locations. And you've seen that it is in fact possible to reclaim these locations and to revegetate them with a uniform cover of appropriate species. Now, staff visited these sites twice in 2021. You heard detailed testimony from Mr. Trujillo on his visits to these sites, documented with specific photos of specific areas of concern. Mr. Trujillo assessed corrective actions based on his expertise, his experience, and the evidence in the field. You also heard Mr. Trujillo state that it is impossible to assess the current state of compliance with the locations without reinspection. Reclamation staff therefore asks that the commission deny Caris's request for a declaration of compliance, rather enter an order simply requiring Caris to complete the corrective actions as assigned. As you've seen, Caris is already doing work towards these corrective actions. Now, if Caris believes these have been completed, staff asks merely that Caris follow the procedures in place to report this work and ask for reinspection. Next, Caris is asking that as the surface owner, it be permitted to waive compliance with Rule 1003. The rule governing waivers requires that Caris demonstrate to the commission's satisfaction that compliance is not necessary to protect public health, safety, and welfare, including prevention of significant adverse environmental impacts. You heard Dr. Arthur's testimony that allowing continued noncompliance at these locations does indeed pose a risk of impacts, and therefore, in her expert opinion, the commission should deny a surface owner waiver. And finally, Caris is requesting a variance, relieving it from its obligation to comply with rules 1002F and 1003. As noted earlier, It is Caris's burden to provide the commission with information showing that their application meets each and every element of the rule. You heard testimony from Dr. Arthur that she's reviewed hundreds of various applications. And you've heard testimony that in her expert opinion, Caris has not met its burden of showing that this application meets all 5 elements of this rule required for the commission to grant the application. Caris has simply not provided the information that meets these elements. Under the rule, the application is insufficient for the commission to grant a variance. Dr. Arthur therefore recommended, and staff requests, that the commission deny Caris's application for a variance. This final slide simply puts together a picture of the relief requested today by staff. We are requesting that the commission deny Caris various requests for relief intended for it to avoid complying with these rules. And we request that the commission enter an order simply requiring Caris to complete the corrective actions as assigned. Once again, thank you, commissioners. And that's all I have.
Okay, very good. As is our normal course, we reserve the right to ask questions at every turn. Does anybody have questions on this on the closings? All right, I'm not seeing any questions. AAG Davenport, should we close the record and move into deliberation? Is that next?
Yes, Mr. Chair, that is the next step.
Do we need to do that via motion, or can I just say the record's closed?
Historically, the commission has closed the record via motion.
Do I have a motion?
So moved.
Second.
Motion and a second. Further discussion? Seeing none, all those in favor?
Aye.
Signify by saying aye.
Aye.
Any opposed? Okay, record is closed. I believe now we will move into deliberation. I, for one, would like to go print out my notes so that I've got them in front of me. So can we take 5-10 minutes and then we can come back and be ready to deliberate? So let's come back at 2:30. That's 12 minutes. We are waiting on Commissioner McGowan. She let me know that she'll be available in just another minute or two. So everybody hold tight. All right, I see a full slate of commissioners as well as a lawyer from either side. So I think we are ready to go. It's 2:33 on Thursday, January 13th, and we will take up deliberations on the matter that we've been hearing for this morning and yesterday afternoon. Commissioner McGowan.
Thank you, Mr. Chair. And I'm wondering if I might ask for clarification, I guess, from council from both sides. I'm trying to work my way through the difference between the waiver request, the surface owner waiver request, and the thing that a surface owner can or cannot ask for a waiver from. And then how that ties into the commission's ability to grant a variance. And is our authority to grant a variance, does that override everything? So we can grant a variance from everything regardless of, for example, the limitations of a surface owner's ability to ask for a waiver. And I hope that what I'm asking for makes sense. But I would be curious to know what counsel for both sides thinks about that.
That sounds good. Thank you, Commissioner McGowan. Why don't we have Mr. Neslin, if you would like to go first. You were giving another opportunity for closing on the distinction between the surface owner waiver and the variance, and what the relief is applicable under either scenario, I think is how I would phrase that question that I heard.
Yes, thank you, Mr. Chair, because I think I heard the surface owner request a waiver, but I'm also hearing council ask for a variance if the declaration of compliance is not an option.
Commissioner McGowan, I think you're right. Karis has requested both a surface owner waiver and a variance. The waiver is limited in this case to Rule 1003. Does not apply to stormwater. That's clear. Both sides, I think, agree about that. It does apply to interim reclamation. And there are no exceptions with respect to interim reclamation. You could waive all interim reclamation. That's not what Karis is seeking. Karis is only seeking waiver of the additional corrective actions regarding interim reclamation. Then separately, Karis is requesting a variance. Variance is a separate rule. That's Rule 503, excuse me. And you can seek a variance from any rule in the rule book, including both Rule 1003 and Rule 1002F, which is stormwater. So both interim reclamation and stormwater. And Karis has requested a variance from both, although again, only as to the corrective actions at issue, not from the rules in their entirety. The requirements for each are separate. So the requirements for surface owner waiver are set forth in Rule 1001C, and generally it is that implementation of the rule in question isn't necessary to protect public health, safety, and welfare and prevent significant adverse environmental impacts. And I think that's the issue that's been joined here. Rule 503, the variance rule, has 4 or 5 specific requirements which have been set forth in the pre-hearing statements. Mr. Goals, did I get that right?
I believe you did. Sorry about that. It's a feedback issue.
Do you have 2 mics in the room there, Mr. Gold?
Dave, I believe you did get that right. I think the only clarification I would make is that the variance standard is set forth in Rule 502. I think the 5 elements are 502C specifically for the commissioner's reference.
Okay, anything further from Karis's attorneys on this question? Thank you for your position on that. Mr. Kirshner would like to hear from you as to the question, please.
Sure. I think council did a good job summarizing the differences. Once again, Rule 1001C applies to surface owner waivers, as council correctly noted. In this instance, surface owner waiver would apply only to Rule 1003, which is interim reclamation. Caris has specified, as Mr. Nelson just did, that they're seeking only to waive further interim reclamation requirements as specified in the corrective actions by Mr. Trujillo. And then the other rule at issue, so the standard for this rule, and obviously, AAG Davenport can feel free to jump in after here, but the standard for this rule is that Caris is required to demonstrate to the directors or the commission's satisfaction that compliance is not necessary to protect public health, safety, welfare, and the environment. As we noted, variances are governed by Rule 502C. Rule 502C requires that the applicant make a showing that all of these 5 elements are met. Now, in this instance, as Mr. Neslin properly clarified, Caris is seeking a variance only from rules 1002F and 1003 as they apply to Mr. Trujillo's assigned corrective actions. Mr. Neslin, did I speak? I don't want to speak for you, so was I correct in that?
Yes, I believe you are.
Okay, I just want to make sure that we're all working with the same standards. So thank you. That's all I have, Chair Robbins.
And if I could,
Go ahead, Mr. President.
yeah, let me clarify. And again, it's been a long day. And so I don't want to lead anybody astray here or confuse things. Caris's papers clearly indicate that as to the variance, Caris only seeks a variance from the additional corrective actions. As to the surface owner waiver, I believe the waiver may apply to further interim reclamation of the well site. Is that correct, Mr. Goals?
That's correct.
Yeah.
Thank you, Mr. Chair. Just a quick question to clarify on that point. With the waiver, excuse me, with the waiver, waiving interim reclamation and therefore waiving any additional actions related to interim reclamation. Am I understanding that part correctly?
Mr. Neslin?
Yes, I believe so.
And so does that essentially deem that interim reclamation is complete?
I believe so.
Okay.
Mr. Goals, do I have that right?
I don't know about that. I think the declaration of compliance and the surface owner waiver are distinct requests for relief. There's a difference here, I think, between acknowledging that the conditions that we've been going back and forth on at the sites comply with the commission's rules, as opposed to the standard under which and the conditions demonstrated by Caris justifying a surface owner waiver of further interim reclamation for the sites. You don't need to recognize that or acknowledge that interim reclamation has indeed been completed to waive further interim reclamation, I think.
Let me ask the question another way. Under your first claim, the deck action, if we were to rule there, you could get all of the relief you're wanting. Fair? Not saying that's where we're going. I'm just trying to understand our pathways. Under the surface owner waiver claim, we could generate relief from further interim reclamation, but not stormwater, right? Everybody nod your head up and down? Okay. And then under the variance, we could, if we make the 5 findings, generate all the relief that you want, right?
Right.
Okay.
Although the only thing I'd clarify is the relief there is more limited.
I understand. The relief you're seeking in all veins is more limited because you've already done, in your estimation, a fair amount of interim reclamation and a fair amount of stormwater. You're just asking relief from the additional COAs.
Mr. Chair,
Yes.
to Commissioner Nanjapa's question though, regardless of what we might decide today, Karis is still responsible for filling out the appropriate forms and paperwork to say we have done final reclamation and then get a sign off from the staff?
For final reclamation.
Yeah. Oh,
Yeah, I
sorry.
mean,
So
yeah.
even for interim, then what happens? Sorry, I'm
That's
back
my-
to Commissioner Nanjapa's question, like, what happens then with interim?
In other words, could staff still go back and say, there's something else related to interim reclamation that still needs to be done in a future inspection? I'm just trying to make sure I'm understanding what we're deciding here.
Are we closing out interim reclamation by some of these decisions?
I think that is what you would be doing. I think the surface owner waiver request is generally applied to interim reclamation requirements for the two sites at issue.
However, if you take what's on the ground now and in 2 years you've failed to maintain it, you're going to have to redo it. You've got to keep it at the level that it's at, assuming that's where we were to go. Is that fair?
Yeah, I think that's a fair statement, and I think Karis would absolutely agree and intend to do so.
Okay. Okay, any further clarifying questions? I'm not sure if this is getting clearer or muddier, but we're in maybe a better spot. All right, so I'm not seeing that. So let's return it to deliberations amongst ourselves, my fellow commissioners. I'll start with some thoughts, and I'm happy to be persuaded otherwise because I'm not really crystal clear in my thinking. But I'll start with, I do not believe that we should grant the declaratory judgment application or whatever the declaratory application is. I believe that an operator should go forth fully through the enforcement process. And I believe that the deck action is sort of a escape valve, route around fully moving back and forth with staff in the enforcement process. I also do not believe that our rules contemplate sort of an operator bringing this sort of action to us. And so that's my first point. I don't, for what it's worth, don't fault Mr. Neslin and Mr. Goltz for bringing the action. I thought it was creative. And I think you were instructed to come to us without sort of a definition of what route you should take, which bus you should get on to get up to us. But I don't like the concept of there being a deck action as some vehicle around moving through our enforcement process. I am inclined to grant the surface owner waiver as to additional interim reclamation. I find that the interim reclamation that has been in place is sufficient and that there is not a concern about additional needs to protect public health, safety, wildlife, and the environment. I also don't find that other component of the surface owner variance, the significant adverse impacts to wildlife, biological resources, that sort of thing. And I believe listening to the testimony from Mr. Russell helps support that. So I would grant the surface owner waiver as to the current interim reclamation that's in place should be allowed to stand, and they need to keep it up to that. And I'm interested in hearing from my fellow commissioners about the stormwater component. I'm not solid in my thoughts about where we should end up on that. And then my final point, which does not have to do with this, or it tangentially has to do with this, is I heard a lot of evidence and back and forth that we've got I'll call it a communication problem between staff and operators on the West Slope. And I'm not going to assess blame one way or another, but I hear operators saying, we don't know how to comply. We don't know how to do the COAs. And I hear that the dialogue that I think Commissioner Gonzalez was hoping to see isn't maybe necessarily happening like it should. And I will step back as director for a while of this agency, and I heard that back then too. And so once we figure out what we're going to do with this particular matter, and I want it to be site specific to this situation, I also would entertain the commission generating a working group to allow one of us to go be the facilitator in that working group to allow for dialogue to take place on these topics. I think we've got the capacity to do that. I think it would be a good idea. And I would like to nominate one of us to think about that. So those are my initial thoughts. I'm interested to hear from other commissioners on where you may be landing. And as I mentioned, I'm also wanting to learn from you about where you may be. Who's next? Commissioner Messner.
Thank you, Mr. Chair. I think I agree. I will agree with some of your points, and then perhaps disagree with one. I think it's my opinion that CARES is improperly attempting to bring an OFV matter to the commission through its request for declaratory relief. I think Rule 503G4 indicates that only the director may bring an OFV hearing to the commission. And while 503G10 indicates any person may seek relief or a ruling from the commission, the fact that 503G4 already applies, in my opinion, it bars the utilization of 503G4. And in this light, I think it's this commissioner's opinion that the request for declaratory relief is not properly before us. So I would suggest we just decline to address this request. As to the variance request, I think Rule 502C indicates that all 5 factors need to apply to all variance requests. I think that this is a high bar and the burden is on the operator in this particular situation. And I'm not convinced that the operator has met that burden for a variance request. I will acknowledge that well, let me go to the surface waiver. And I'm happy to go into specifics of each of the 5 pieces, but in understanding that holistically they have to meet all 5, I don't believe that, I particularly don't believe that there's an undue burden in this particular situation. As to the surface waiver, I think that the location itself and the fact that it is in a high priority habitat, that it's adjacent to a riparian corridor, that it's on unstable slopes, those all indicate to me conditions that do potentially affect public health, safety, welfare, the environment, and wildlife resources. And during the mission change rulemakings are areas that we put extra emphasis on as far as developing rules around those. And so while it's possible that some of the best management practices that are associated with this particular, these 2 particular sites, it appears to me that the vast majority of them are in place and are working. And I think that there is, and so I'm not saying that there's an imminent threat, but there certainly is the potential for a threat there. So I'm not inclined to grant a surface waiver in this particular situation either. Now, having said that, I do concur with Chairman Robbins around the communication issues and the general understanding of operators around what the expectations are for interim reclamation. I think that there has been testimony from both sides that conflict a little bit as far as what the expectations are. I think that there's confusion between performance-based standards and prescriptive standards. And so I think that a dialogue and a communication and a working group to help better understand and to better facilitate the opportunity to work together to clearly understand what the expectations and the regulations are, and to better help operators comply with those regulations, because I do believe that Caris is an operator that is attempting to comply with the regulatory requirements of the Cogcc. And so, so I appreciate Chairman Robbins' thoughts around potentially putting a working group together. I'm certainly, I would be happy to participate in that working group, but certainly would defer to another commissioner if they are interested in taking on that role.
Commissioner Messner, Commissioner Nanjapa.
Thank you, Mr. Chair, and thanks to you and Commissioner Messner for getting the ball rolling here. I think I generally agree with the points that have been raised, particularly by Commissioner Messner. I also believe that the declaratory relief is not coming to us through the proper channels. And, I don't believe that Caris has met its burden as to whether it's complied, which is part of the request. But more specifically, the proper channels haven't been followed, attempted or exhausted in order to come before the commission per Rule 503G regarding these types of hearing applications. And, I do want to agree with Chair Robbins' comment that it feels like an end around of our inspection and enforcement processes, and suggests that any matters can be brought to the commission whenever there's a disagreement between an operator and an inspector. So I'm not comfortable with that at all. So I believe we should dismiss the request for declaratory relief or whatever, or just not address it, whatever the appropriate way to say that we will not take that up. Regarding the variance, I think, well, let me go, the surface owner waiver. I don't know how much we can split hairs here, but I think I would be comfortable with the aspects of interim reclamation that involve restoration of, for example, in, I think it's H29 that had the triangular area that we kept talking about. Just leaving that be, and letting kind of natural ecological processes allow for the revegetation of that area, but perhaps also not necessarily maintaining the bare ground that is there now. And all that said, maintaining all of the requirements to prevent the adverse impacts to the environment, the stormwater erosion, and other measures that would normally occur in inspections, would still be relevant there. In general, for the variance request, I feel that this is a bit of an unusual set of circumstances, particularly as it relates to the first of the 5 criteria in terms of the good faith effort to comply. While I do sympathize with the breakdown in communications that occurred, I don't think all the channels were explored with respect to communicating with the commission and trying to comply with the specific requirements, and that this again is an attempt to kind of go around a disagreement and just get out of the requirements. So I'm again not comfortable with that. I think generally speaking, I guess maybe I'm still a tiny bit unclear as to whether the surface owner waiver and the variance request are two entirely separate things. But if they are, then as I noted with the, certain conditions with respect to the surface owner waiver, I could maybe go forward with that. With the variance request in general, in my view, we should deny the variance request and direct the staff to work with Karis to resolve the inspections and the corrective actions. And I support the suggestion that Chair Robbins, you brought forward about a mediator or a working group or something to help facilitate that moving forward. So that's where I am.
Commissioner Gonzalez.
Thanks, Chair, and thanks to Commissioners Messner and Joppa for kicking this off. I'm going to kind of run through some of my thoughts in general. I'm going to start with the declaratory relief, basically declaring that the corrective actions have either been met or are not necessary. And I do want to acknowledge that there was probably some reliance on staff suggestion this be brought before the commission. I don't think that was an appropriate suggestion. I don't think it was an appropriate to bring it here even after that suggestion, but I want to acknowledge that because we shouldn't be a mid-process tiebreaker, right? This is kind of right in the middle of the enforcement action. There's an inspection, there's corrective actions. If those corrective actions aren't meant, staff has the ability to file an NOAV. If there's no agreement or if that's contested, then it will come before us. So we're really getting the meat of what's going on there. Really look at the really a more in-depth review of those corrective actions, what did not happen, and the application of those rules. So that's kind of where I stand on declaratory relief, is that I'm not inclined to grant that relief at this point. As the surface owner waiver, I do think that this is appropriate as to 1003, basically as the additional corrective actions that were required for interim reclamation. Karis is the surface owner. It seems to be a pretty deliberately managed area. The ranch that they're on, it doesn't seem to me like Karis is using this area just to store their messy things and to really not apply the rules to their operations on their own surface. There's no public access there, and again, they've got deliberate plans for grazing, for their wildlife management on there, and I found those things to be reasonable and to have an appropriate amount of protections that do meet the intent of our act on that surface. And so that being said, I am inclined to grant the surface owner waiver for 1003 as the additional corrective actions for interim reclamation. As to the variance, kind of take these. So first of all, I want to make a comment, right? I think that this variance appears to be in response to corrective actions that Karis didn't necessarily agree with versus a proactive ask for a relief from a rule. And I think that a variance, when it comes before us, should have some intent to it, a little more forethought, and not so much just a reaction to an enforcement process that there was some disagreement on. As to good faith to comply, I think that given what we heard from Karis, that they thought they were doing the right things under the rule, that they took this in the condition they accepted it from Encana, with the inspections that had occurred from 2012 to 2016 while it was under, I guess, under the previous realm. And then when the inspections came up in 2021, there was just disagreement into kind of the extent of the interim reclamation and the extent of the stormwater protections that were occurring on site. I think there was good faith to comply. I don't think that their actions or that the variance would violate the basic intent of the act. As to the necessary to avoid undue hardship, I'm not sure I'm convinced on this, but in terms of the way we view undue hardships, really it's site specific. It's not whether or not someone actually can do it, it's whether or not it's appropriate to the site. And I don't know that, I think I'm stuck on this one a little bit. So I don't know that I'm ready to specifically make a determination as to that one element just yet. That the rule isn't necessary to protect against adverse impacts. Again, we heard competing testimony from our staff experts and from Caris's experts, but they were essentially talking about a site in two different conditions, right? I think that it was obvious that additional work occurred on that site that was subsequent to the staff inspection. And I don't think we're looking at apples to apples here when we're considering what was brought to us by Caris's stormwater expert and by their environmental expert and the pictures that we saw versus what staff looked at even days before on July 22nd with some of those pictures that we saw there. So in that regard, I don't necessarily know what the current condition is and whether or not that would or would not protect against adverse impacts. I'm inclined to think that it would, but again, that's kind of where I sit in that regard. And then lastly, as to whether it contains reasonable conditions of approval or other mitigation measures, I don't think that's necessarily an appropriate consideration in these 5 things, because I think Caris is basically saying that their actions, their efforts as to the application of these rules are protected enough. But that being said, I think on the variance, I don't have enough information to really believe that Caris has met its burden for us to grant that. So I am not inclined to grant a variance to Caris on rules 1002 or 1003, absent the surface waiver for 1003 specific to the remaining corrective actions. So that's kind of running through my notes. I'm not sure if I missed anything. I'm happy to clarify, but that's kind of what I have right now, Chair.
Thank you, Commissioner Gonzalez. Commissioner McGowan, do you want to weigh in? You don't have to. We can go to somebody
Hate
else.
going last. I'm going to raise my hand first next time, so somebody else is stuck in this seat. I'm in agreement with the other commissioners about the declaration of compliance or declaratory relief. It feels really premature to me. You haven't gone through a process and said, I wasn't treated fairly, this rule was not applied appropriately. I'm not even sure there's an actual enforcement action yet. There's been corrective actions, but there is no NOAV, there is no OFV. I'm trying to figure out what we're responding to other than a disagreement about a corrective action where both sides admit no dialogue has taken place as to trying to figure out some sort of middle ground or other ways to meet expectations. So I agree on that piece. I am with Commissioner Nanjapa where I'm really struggling with the surface owner waiver. The site size and which pieces are still being used or not used. Yeah, I think both sides have some really compelling arguments, and I'm not sure feel the need to follow my sword about that piece, and I'm inclined to provide surface owner waiver for that piece. I feel like we have seen some pictures and some evidence and testimony where I have concerns about the slope and revegetation and erosion. And I think that that is related to the interim reclamation, the vegetation piece. I'm having trouble slicing and dicing when we're talking about best management practices for stormwater protection. I do think that in some cases it includes this revegetation piece that prevents erosion and then sediment and other things from flowing and moving to another location, which is what we're trying to prevent. That being said, other than it being a high priority habitat, I don't feel like there is water near the site that is in immediate jeopardy or would face adverse hardship or harm if we granted the surface owner waiver for the interim reclamation as far as revegetation. So I feel like I'm a little stuck there, and I'm sorry that's not helpful. For me, the stormwater protection is a really beefed up piece in our rules because it's super important. And in addition to that, CDPHE has a stormwater rule, which we are trying to implement for them. And they updated it, and it's a very important piece of our rules because it's the piece that prevents things that prevents erosion, prevents potential bad things that are on site from migrating to other parts of different areas that might be high priority habitat, might be waters, important waters. And I don't know, I'm not an expert in best management stormwater practices, but I also feel like the conversation with our staff hasn't been able to work its way through so that you come to us and say, we offer these other things as solutions, and staff just flat turned us down, but they are equally as protective. There's no adverse impact if we do X or Y or Z. Instead, I feel like what you're saying is we don't feel the need to do anything else, and we want you to give us a variance. So I'm really struggling with the fact that y'all haven't gone through a process for me to say, well, that really didn't work out very well, and we didn't apply those rules appropriately or fairly or non-arbitrarily. And so back to Commissioner Gonzalez's point, though, I feel like staff told you to come to us. And so that kind of puts us in this weird conundrum. So I'm not being helpful there. And then the last piece is I think there should be a working group that gets put together, and I think it needs to be more than about communication issues. I think we need to really figure out what is our role as a commission in regards to compliance assistance. Yes, we are regulators, but part of our job should also be to show a regulator how they can be successful under our rules. What are our expectations? What are we looking for? How can you succeed and meet those expectations? And I'm just not, I also, having been on the Western Slope recently, as our commission did, I think that we heard from operators who are frustrated with, we would like a little more information on how to be successful, and we're not getting it, and staff seems really hesitant to provide that anymore. So I think that there needs to be maybe a discussion and some training around expectations from a regulatory perspective and from a compliance assistance perspective. I will also say that it could benefit this working group to sit down with CDPHE and do a joint training on stormwater best management practices. That it is their rules. Everyone who testified today said, I'm a certified stormwater best management practices inspector or compliance manager or whatever. And everybody thinks that they're touching the elephant in a different place, and we are or are not meeting expectations under the stormwater rules. So I guess those are my thoughts about if this working group is going to be put together. I think there needs to be a meeting with CDPHE and with operators and our inspectors with specific examples of this meets expectations, this does not, this is what we're looking for, this is how far you need to go. I'm done.
Thank you, Commissioner McGowan. I don't know that I followed precisely where you landed on the surface owner, but I don't know that I need to go there if I'm counting votes. So let me just sort of summarize where I think we are. I think we have 5 votes to decline the deck action, or whatever it may be, to not entertain the deck action. I think I heard at least 3 votes that the surface owner waiver would be granted as to 1003, and that there would be not a need for additional interim reclamation. And I say 3, and that's me, Commissioner Nanjapa, and Commissioner Gonzalez. I believe that Commissioner Messner was a no vote on that, and I wasn't sure where you landed, Commissioner McGowan. So, but I don't know that you need to land, because we just need 3 to get through this and be done. Commissioner Messner.
Thank you, Mr. Chair. I think I need to understand a couple of things here, because I think what I'm here, what I think you guys think is that if we grant this surface owner waiver, that no additional reclamation needs to happen, on the particular site. What I'm not sure is exactly, what I'm not sure is exactly what you think that means, right? Because I do think that, at least from this commissioner's perspective, stormwater management does include the vast majority of what this surface owner waiver would exempt, right? And so when you're talking about, the erosion, you're talking about the vegetation, you're talking about the soil stabilization, this is all stormwater management, right? This is all the stuff that CDPHE requires. It's all the stuff that we do not allow a surface owner waiver to exempt, but at the same time, if we offer this surface owner exemption, are we just talking about this compacted areas? Is that what we're talking about you're exempting? Or are you thinking that no additional vegetation needs to occur or no additional soil stabilization? Or I guess I'm not understanding exactly what you think this surface owner waiver is going to do.
Let me call upon AAG Davenport to appear before us. AAG Davenport, can you, having heard the deliberation and having heard the good question from Commissioner Messner, it does appear that there are 3 tentative votes to grant the surface owner waiver. But my understanding is that's just as to additional interim reclamation things that do not have to do with stormwater, because my understanding is that we cannot do a surface owner waiver for stormwater. And so we would be sending this back to Karis and staff to understand that, like, I agree with you, John, or Commissioner Messner, sorry, that, you know, there's that compact area, or there's that area where they need to be able to continue to use it. My perspective is that would be sort of solidified and would not need to be readdressed. The measures that involve stormwater, which I don't believe we can waive, and I'm counting the votes, it seems like everyone is not in favor of granting a variance, so they would still have to comply with whatever additional interim reclamation measures that address stormwater. AG Davenport, can you help me or help all of us with sort of this issue?
Tentatively, yes, maybe. I think, well, I'll start with kind of a reiteration and see if it's helpful. Rule 1001C provides the commission shall not require compliance with Rule 1003. I'm focusing on interim reclamation, Rule 1003 right now. If the operator demonstrates that compliance with such rules is not necessary to protect public health, safety, and welfare, including the prevention of significant adverse environmental impacts, and the operator has entered into an agreement with the surface owner regarding topsoil protection and reclamation of the land. So that is in regard to everything covered under Rule 1003. That's the waiver. So if the commission grants or approves of, in shorthand, the waiver, there shall not be further compliance with Rule 1003, though, and again, I don't want to put words in anybody's mouth, my understanding is Karis, through council today, has acknowledged that they would need to keep things in the condition that they are now at those locations, could not let them deteriorate from the current conditions. Rule 1001C does not allow for a surface owner to waive the stormwater requirements in 1002F, as in Frank. So the commission approving of the waiver would still leave continued ongoing compliance with stormwater protections under 1002F. An additional action would need to be taken by the commission to provide relief to Karis for the stormwater protections. And that, given that I believe the commission is already tentatively concluding not to grant the declaratory relief, what that falls to is a variance.
And I think that we've had 4 musings from commissioners, or 4 commissioners that are, or 3, but I'm concluding myself, that are not inclined to say they met the burden of proof on the variance.
Commissioner Messner, I'm not sure that what I just said answers your question.
Thank you, Mr. Davenport. I think it does. I mean, if you, I just want to make sure everyone understands this. If you look at 1002F, right? You know, and particularly 2C, there is a specific thing in there around erosion control. And the fact that, soil management and erosion control and vegetative cover, at least from this commissioner's opinion, would all be required and covered, under that, even with a surface owner waiver. And so while I think it could be argued that there may be some compacted areas that could potentially stay compacted, or at least that's what I'm hearing some commissioners indicate. I do think for me, it's incredibly important that we maintain stormwater management. We maintain stormwater management for the big events, right? It's not for, the 12-hour rainstorm. It's for the 25-year, the 50-year storms. And these things do happen on the Western Slope. And I think it's incredibly important that we maintain it, particularly in the high priority habitat and the riparian corridors that we're talking about there. So, I can actually get on board if we're clear that the surface owner waiver really is only talking about the compacted surface areas and nothing else. And that it is clear that that's the case. So I'll leave it at that.
Thank you, Mr. Chair. So I agree, because if I'm understanding the original conversation we all just had at the beginning, the surface owner request waiver is for 1003. 1003E is restoration and revegetation. So my understanding is that this surface owner waiver request, if it's in regards to 1003, would include a waiver from revegetation of non-crop lands. And so I think we have to be super clear. Otherwise, we're going to have staff and the operator at odds over which pieces are 1003 and which pieces are the stormwater 1002F.
I couldn't hear you, Chair, but I think you may have recognized me. So my understanding of really what's being asked for in 1003 with regards to the surface owner waiver for interim reclamation is basically a determination that the extent to which the reclamation exists, the bounds of the reclamation is kind of, that's where it stays, right? But if that extent and that interim reclamation has stormwater issues, if it has noxious weeds that pop up, if it deteriorates its current condition, that those are still subsequent, are still within the staff's ability to enforce subsequent to this determination. Kyle, can I stop there and you can tell me if I'm on the right page? Then I can keep on going. A.G. Davenport, I think that's your cue.
Yeah, that's fine. Yeah, I believe you are on the right page. What we're talking about here is obviously interim reclamation, and that's the service owner waiver request. So I think you are on the right track.
So what if we, I mean, and I'll look to CARA staff as well, because I want to make sure that we're addressing what's being asked for to CARA's council is, are you essentially asking for relief or a waiver of all of 1003? Is it a waiver of 1003B, talking about areas that are no longer in use? Because that's part of the dispute, is that there's areas that CARA says, hey, we are using these, we need these, and it's in our purview to keep those as surface owner, and that's why we're requesting this waiver, despite disagreement with staff. Is it compaction alleviation, saying that within that area we just talked about, that we shouldn't have to dig up our compaction, we should be able to leave it as is? Drilling pit closure, I don't think applies in this case. Restoration or revegetation, is that restoration or revegetation that's being asked to be waived only to the extent of the current existing bounds of the interimly reclaimed area? If that's the case, and I think we can put the appropriate bounds in terms of what this waiver is. So we're not just saying D28 and H29 that 1003 no longer applies to them, right? Because that's a step too far, in my opinion. And I don't think that's what CARAS is asking for. So with that in mind, I'd like to turn it over to Mr. Neslin or Mr. Goltz to clarify if I'm on the right track, or if you guys are asking for anything more than what I'm suggesting that, you know, that we grant as a waiver.
I think that's fair. Mr. Neslin?
Yeah, I think that's a great question, Commissioner Gonzalez. I'm at a little bit of a handicap because I am 15 miles from my clients. And I don't want to misstate their position, but as a general matter, my understanding, and I might ask Mr. Goals to, if he's with our clients, to confirm with them.
Mr. Neslin, hold on. I appreciate that point you just made. I would like to give you an opportunity to speak with your client now that you've heard kind of the initial place that the commissioners are tentatively arriving at. I'd like to get this wrapped up, but if I could give you 10, 15 minutes to jump on the phone, Mr. Kirschner, I believe you could do the same, and then we could reconvene and perhaps get this thing wrapped up before our 4 o'clock hard stop. So 10 minutes, maybe 3:30.
10 minutes. 10
Sorry.
minutes, Chair.
Could you all be super clear about when we're talking about revegetation and which areas and pictures and photos we've seen you think would apply for the surface owner waiver or not? That's really what I'm stuck on. Sorry, I'm really struggling with that piece.
Okay.
Thank you.
Short break till 3:34. Thanks, Hearing Manager Amaro. We will await the arrival back of Mr. Neslin and Mr. Goltz.
Thank you, Mr. Chair.
Okay, I think what the commission would like is to hear ever so briefly from Mr. Neslin or Mr. Goltz, and then also from Mr. Kirschner. You've heard our sort of initial thoughts about this process. We've taken no votes, but we would like to hear from you in line with we're 5 votes in favor of not granting the dex action. Generally speaking, 4 or 5 votes against the variance, but to grant the surface owner waiver and what that would mean.
So let me begin, and then I'll have Mr. Goals. I'll hand it off to Mr. Goals, who's there with our clients. I believe that Commissioner Gonzalez was approaching this. I generally agreed with what I heard Commissioner Gonzalez saying in his approach to this issue. In my mind, we're talking about waiving the revegetation requirement at the 2 sites, but not limiting the obligation to control erosion under Rule 1002F. And if under Rule 1002F, the appropriate BMP for minimizing erosion would involve additional revegetation, then that could be required under Rule 1002F. That's kind of the way I'd set it up, and then maybe Mr. Goals could could add to what I've had to say.
I think that's the most accurate depiction of what Karis is looking for here. I think the main concern is that they have acquired sites which undertook interim reclamation by a previous operator, and the established working surface and size of the reclaim is now being questioned, many years later. The primary concern being whether the pad needs to shrink more, and whether the compacted surfaces that are present and not showing signs of erosion need to be reduced further. I think Commissioner Messner has raised a really interesting point, which is that, pains were taken to revise the surface owner waiver to not apply to Rule 1002. That's clear from the rulemaking. And it appears that there might be, as Mr. Neslin mentioned, questions raised by the extent to which the requirements overlap. But I think what's crystal clear is that whatever revegetation requirements are imposed by Rule 1003 would not be imposed for either of the sites.
Mr. Kirschner?
Sure, I actually think we're pretty close here in our interpretation of this. Obviously, staff is recognizing that it seems clear that the commission's intent is to grant this surface owner waiver. And if that's going to happen, I think we don't necessarily expect that Karis would have to reduce the working surface size any further if there is to be a surface owner waiver. So we would agree with that. Our position is that the slopes and the location obviously must be maintained and stabilized pursuant to stormwater regs. And I think that's what Mr. Neslin hit on as well. We would certainly like to see that there are portions of the D28 that are undergoing revegetation. Those portions are progressing. We would certainly like to see that revegetation progress. I don't think there's any need to figuratively cut it off at the knees. So we'd certainly like to see that revegetation at the D28 progress. But having said that, we're not expecting Karis, if there is a surface owner waiver here, to necessarily do any new ripping up of land or replacement of soils or anything like that. I think that's about as close as I can get to a statement of our position.
So I'm thinking about next steps. Thank you all for convening with your clients and bringing this back to us. I'm going to propose something. Back when I was a lawyer, which I'm not anymore, there have been opportunities where the judge, after sort of revealing where he was going to be, would ask the parties either jointly or independently to come back to the judge with a proposed written order. I think you guys have heard from us, and you might do a better job of crafting a proposed written order that you could both agree to, that your clients could agree to, and bring that back to us at our next meeting. And we could stay further consideration until we have a chance to take a look at that. And that's a off the wall idea. It may be the dumbest thing in the world, but I floated out there for the parties to think about, and my fellow commissioners. I haven't talked with them about it either. Commissioner Gonzalez.
Yeah, I mean, I think that's a fine idea, Chair. I think there's been a lot of kind of confusing points that were tried to capture in the application and the statements that we're now really digging into the nuance in. And I will say that I appreciate the responses from both sets of counsel, and I specifically agree with the language that Mr. Kirschner used in kind of summing it all up. And I saw some head nods by Mr. Neslin, Mr. Goltz. I think you guys are pretty dang close to being aligned there. And so that's the language that I think could be clarified and would benefit from some clarity in a thoughtful proposed order from you guys. So I do agree with that suggestion, Chair Robbins.
I see Commissioner Najapa.
Thank you, Mr. Chair. And yeah, just echoing what Commissioner Gonzalez just said. I think this was the piece of it. When I mentioned I was sort of confused by the surface owner waiver and what it actually is entailing. is, if we could just make sure, as has already kind of been said, that we're very clear on which provisions within 1003, especially if there are any that you don't believe need to apply to the surface owner waiver, then that would make it very clear, and again, acknowledging that the 1002F still applies. But yeah, other than that, I like this idea. I think, obviously, ideally, this is what would have happened before, not necessarily involving council, but that you guys are going to help get to an agreement. And the one question I had is, would this come to us? It would just be an order then related to this matter, not an AOC, correct? Okay.
Yeah, I think it would be an order that it would be our order.
Okay.
And not something that is an AOC. AG Davenport has appeared with us, and let's see what he thinks.
But commissioners, I don't have any problem with the concept. I think I was popping up to maybe get some clarity and to offer my services in aiding in that drafting process, if that's the pleasure of everyone.
It is our pleasure.
Okay, thank you. Happy to do that. I am also, I think my other follow-up question was if the commission was looking for kind of a comprehensive drafted order, or if the request was really for the parties to be involved in only kind of the specific piece of the surface owner waiver portion of the order. Ultimately, we'll have an order that covers more things, more topics than just that.
Let me run a variation on the theme here. AG Davenport, why don't you, so you're going to draft a comprehensive order because that's what you always do. Why don't you work on that? And then with regard to this surface owner piece, why don't you draft but get input from both sides, if that's okay? That way, the order, which is ours, is being drafted by our council. And then when you're ready, bring it back to us, and then we can formalize this matter. And again, we're making this up as we go, but is that okay, AG Davenport?
That's fine with me.
Okay.
Chair Robbins, if I might try to get some guardrails, just so we have kind of a guideline for how we're going to do this, I would propose that the parties have input on the proposed order only to the extent that it applies to the surface owner waiver.
I think that's fine. I think you've heard categorically on the deck and the variance. So it's just the surface owner and what is meant by the place that we've landed.
Thank you, Chair Robbins.
Okay, AG Davenport, do you want us to vote today, or should we just continue this matter to next Wednesday or whenever you think you might be ready?
Well, assuming we can get it done, I think continuing it to, and I apologize, I don't have the schedule right in front of me. Perhaps,
Wednesday
do we have a hearing next Wednesday? Yes, we do. Okay. So yeah, it seems getting this concluded prior to the financial assurance rulemaking makes some sense. So I think I would need just confirmation of where I think the commission is headed on probably the variance piece. I just confirm.
Yeah, no, so my count has 5 votes no on the deck piece. It has myself, Commissioner Messner, Commissioner Nanjapa, and Commissioner Gonzalez, based upon one of the 5 elements not being met, as a no on the variance. Commissioner McGowan, I apologize, but I do not understand exactly where you were on the variance. And you do not need to make a record of it because 4 is a quorum. So
I'm a no on the variance. And if the surface owner piece gets worked out between both councils, then I'll be a yes on that.
okay, so then we are in alignment, assuming the surface owner piece gets worked out.
Okay, thank you. I appreciate the clarification. What I'm going to suggest, I think, is not a final vote now. We'll treat this kind of a la the mission change rulemaking, the commission has essentially made its decision. The decision will not be final until the commission reviews the written order tentatively next Wednesday.
Okay. Okay, so thank everybody. At this point, I think we are done in terms of the initial deliberation. I did want to put Commissioner Gonzalez on the spot. My notes, I did not hear from you about the working group concept, or if you said something about it, I didn't take a good note about it. Did you have thoughts about that?
I think he might be having audio issues.
Chair,
Can you hear us?
I didn't hear anything that you just said. I don't know if it was my computer or not, but
Oh, okay. What are your thoughts about the working group concept? I don't know that I heard you on that, and if you said something, I apologize.
me individually,
Yeah,
I'm fully comfortable with that. I think it's great. I think we really need to dial in the communication bounds and expectations between staff and operators. So I'm in favor of it.
okay. And I think what we should do is we can work offline on that and put something in, in writing, get something together, and then bring that back to ourselves for consideration. And we can discuss that with staff. Since Karis brought this matter to us, we can discuss that issue with Karis as well. And that's a good idea. That's got 5 votes, and so, or 5 yeses. So we will work that up. And I want to thank, well, you didn't ask for it, but this generated this idea, which I think it can be successful for Cogcc, for operators, and for our commission as a whole. So good. With that, if there's nothing further, I believe we have concluded the commission's business today. I believe we would look for a motion to continue docket number 2108-00131 to January 19th.
So moved.
Second.
Great. We have a motion and a second. Further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Motion carries. Thank you to counsel for both sides, to the witnesses. I think that we all are appreciative of the method of bringing this to our attention, and very professional all the way around. So thank you very much. We will see you in a week. Mr. Davenport will see you between now and that week. And at this point, I think we're looking for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye.
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 Great. Thanks, everybody. Talk to you soon.